the second legal symposium organized by the Bar Association of Sri Lanka. So before we commence the rest of the technical and the academic sessions for the day, I cordially invite Mr. Pasindu Silva for the opening remarks of the session.
A very good morning to all of you. This is the second symposium held after President Rajiv Surya assumed office, and yesterday we had a very interesting day. The day commenced with an address and presentation on wildlife, its wonders and its perils from enthusiastic perspective by Mr. Dushant Silva and Mr. Milinda Vattagedara, members of the research and data gathering team of Gala Center. It highlighted the wonders of nature that we have in this beautiful country and the importance of protecting them. Next was the session done by Honorable High Court Judge Udesh Ranatunga on the topic review of Section 66 actions, recent trends. Honorable Udesh Ranatunga, in a very captive manner, went through the law and the judgments on Section 66 actions. His presentation was a very detailed one, highlighting the latest authorities on this subject. Next, we had the session done by Mr. Upali, Promoted President's Council, on the topic fair trial. He started the session giving us the conceptual understanding of fair trial. Then he went on to discuss the constituents of a fair trial and the provisions of the law and judgments relating to the topic. He emphasized that as practitioners, we should be well prepared and be innovative in presenting our submission to the court, and gave several examples on this aspect. The last academic session for the day was on the subject, role of a notary cum attorney on execution of deeds by Mrs. Shiranta Gunawardena, Senior Instructing Attorney at Law. She drew the attention to the changes in the law and the practical aspects in attending to the duties of as notaries. Ms. Gunawardena, with a wealth of experience, emphasized that we should be very vigilant and take all precautionary measures in executing notarial documents. Then in the evening, we had the excursions in Udawala National Park, and many of you enjoy the wildlife and the scenic beauties of this location. Thereafter, we had the fireside chat with the President of BASL, where many important topics relevant to our members were discussed. This followed the fellowship with music, and I hope that all of you had a very fruitful day yesterday. Today we have sessions on debt recovery laws by Mr. Priyantha Alagewanna, who has been here well prepared from yesterday itself. And the next one on enlarged scope under the Anti-Corruption Act by Mr. Ranga Disanayake, Director General of Commission to investigate allegations of bribery or corruption. So I'm sure that today's program will also be very interesting, and I'm thankful for all the participants for the enthusiasm shown by you all in engaging in all the sessions as well as other activities, because these resource persons have come from very far away, like many of you all as well. So let's hope for a very enterprising day today. Thanks. Thank you very much.
Thank you, sir. To formally commence today's technical sessions, I would like to introduce our first esteemed guest, Mr. Priyantha Alagewanna. Mr. Alagewanna is an accomplished attorney at law with over 22 years of experience in civil and commercial law. He holds an LLB from the University of Colombo and LLM from General Sir John Kothalavala Defence University, and is currently pursuing a PhD at the University of Colombo on debt recovery legislations. While specializing in banking and commercial law, he serves as a counsel to leading banks and corporate groups, and is an arbitrator with the ICLP and Sri Lanka Arbitration Centers. He is a long-standing editor of the Bar Association Law Journal and Sri Lanka Law Reports. He has held key leadership roles within the Bar Association of Sri Lanka, including the chairman of the Civil Law Committee. Mr. Alagiyavanna is also a frequent resource person at legal forums and an active contributor to law reforms initiatives. Dear Sir, the stage is yours.
Mr. Pasilu and other participants. Good morning to all of you, and thank you for the kind introduction. I have been asked to speak about the debt recovery law. Now, if we are to speak about the debt recovery law, first and foremost, we have to identify the nature of a debt, a transaction in issue. Now, in Sri Lanka, once the son of late N.E. Veerasurya QC remarked that Dr. Vikrama Veerasurya, renowned author, in Sri Lanka, recovery of money is a mission impossible because the intrinsic nature attached to debt recovery in Sri Lanka. Why he has stated that? Because our process, as of which we are a part of, is a very cumbersome process when it comes to the recovery of money. So I can see there is a cross section of legal paternity are present here. Basically, we have our senior attorneys from the BOI, from the banks, and there's some civil and criminal practitioners. So I'll try to generally address all of you in a general context so that we can get a certain idea about the debt recovery. So debt recovery law regime in Sri Lanka can be mainly classified into a legislation after 1990 and before 1990. Now, in a debt recovery transaction, there is a debtor, there is a creditor, the person who lent the money and person who borrowed the money. So before 1990, if someone lent the money to another person, basically the remedy available to those persons were filing a regular money action under the provisions of the Civil Procedure Code. So one remedy. Then if there is a mortgage bond, to file a mortgage bond action. Then third one, of course, if there is an instrument such as a promissory note or check, file an action under Chapter 53 of the Civil Procedure. That is on liquid claims. We'll make it very clear. One is a regular action based on the contract. The contract can be written or unwritten. Then, based on that, before 1990, anybody can file action under regular law, under CPC. Then, Mortgage Act was enacted by Act number 6 of 1949. When there is a mortgage, by following the procedures set out in the Mortgage Act, such as filing a list pendants, a declaration under the hand of notary, attorney at law, under Section 8 and 9, a judgment can be entered to declare that mortgage property is liable to be sold for execution of money decree. So you will understand that under Section 7 of the Mortgage Act, action known as a hypothecary action, Section 2 action known as a hypothecary action, and another action under Section 7, a combination of money decree and hypothecary action was introduced. So anyway, I am going to focus on the laws presently used after 1990. So I'm just giving a brief outline of the law which were used to apply to recover money before 1990. So now what happened? All those actions were time consuming. And you have to file a claim, the defendant can file an answer, then the issues will be framed in a civil matter, evidence will be led, thereafter judgment will be delivered. As our system, which is somewhat fragile, it takes a lot of time to happen all this. Now, even at the end of the day, there is no guarantee, even after appeal process, you will be able to recover the money if a facility or the money you have lent without a written security, like a mortgage. Now, so in order to remedy these things, the legislature wanted, of course, due to demand by the business community and the bankers, they wanted the institutions such as finance company and the bankers give us lifeline. So how it happened? Now initially, Mortgage Act is a general act applied to everybody. Bankers, ordinary people, everybody used to apply the Mortgage Act to recover their money. If there is no mortgage, people used to file an ordinary action. So if you have an instrument such as check or promissory note, you could file an action under Chapter 53 of the Civil Procedure Code. Now what happened in our financial system? There are various type of players who advance the money. And under our law, only commercial bank, licensed specialized bank, other banks which were enacted by the Act of Parliament, and the finance company can accept deposits and pay the interest. So that segment of the financial sector, the central bank and the other authorities consider as a main set of people who drive our economy. So beyond that, there are other type of money lenders. You see that those people which I had adverted a moment ago, they are authorized by the Act of Parliament which was enacted in 2010 to accept the deposit and pay the interest. However, when it comes to the other companies, there are some other companies who are engaged in the business of money lending. They are not permitted, however, to accept the deposit and the pay interest. So the legislature, in order to give a lifeline and also to enable them to recover their money in a quick and expeditious manner, in 1990 enacted Act number 2 of 1990 and 4 of 1990. Now, I'm trying to focus my discussions on this Act number 2 of 1990 and 4 of 1990. Now, so I have given a brief introduction of the importance of the money and credit in a modern society. And so perhaps no single factor can do more influence than the welfare and growth of the economy than the flow of money. Then now our first governor of the central bank who came from America is the person who made this statement way back in 1949. Then as I have stated in this slide, so when it comes to the money recovery, the focus of this discussion will be Debt Recovery Act number 2 of 1990, Recovery of Loan by Bank, Special Provision Act number 4 of 1990. I will briefly deal with the Mortgage Act also. Now, in 1990, basically two drastic legislation were enacted. One is Act number 4 1990, that is Parate Execution Law. That is, we are going to discuss that today. That is, the lender, the banks were permitted by the Act number 4 1990 without going to the court to realize their security. In short, to sell the property by extra judicial process of Parate execution without going to the courts. At the same time, the legislature enacted Act number 2 of 1990. So Act number 4 of 1990 and Act number 2 of 1990, those are called special legislation, special provisions. Now, special provisions always prevail over the general law. And when it comes to the rule of interpretation, if you read the Vinra, it always say the special law prevail over the general law. Now, while the legislature, parliament, gave the power in respect of the Parate execution to the bank in 1990, they allowed some leverage and provided some procedure to the finance company also, which are regulated by the central bank by bringing them a legislation in the form of Act number 2 of 1990. So we'll have to first identify who can avail this law. Now, if I give some money to Pasindu, I can't avail the Act number 2 of 1990 or 4 of 1990. So, this legislation can be applied and used by special class of people, namely bank and financial institution, as referred by these acts. So, if ordinary litigant come to us and he tell us, I gave my neighbor sum of rupees 10 million, he gave me a mortgage bond, we can't go for a Parate execution, we can't file a debt recovery. Why? Only the banks and the financial institutions were allowed given this power because they form the trust or the most important core I would say, core financial institution who run the country. So they basically lend the money to the people for economic development of the country, and money must be available again to re-lend to the other person. To enable that process, the money once lent must be recovered quickly. So accordingly, as shown in this slide, licensed commercial bank, companies registered under the Finance Act, and the other state-controlled bank which were enacted from time to time, NSB and the National Development Bank, DFCC, and also regional banks now. Those are the ones who are considered as a lending institution under Act number 2 of 1990. Only they can file the action. Now in the last year, the legislation was brought by the parliament allowing plaintiff to file action depending on his residence. I know there is a strong criticism to that, and even Bar Association is seriously looking into we have made a representation to change it. Now, accordingly, as per the law stand now, an action can be filed contrary to the previous section 9 of the CPC, depending on the residence of the plaintiff also. Now, using that, many actions are filed in the DC Colombo, depriving the people from the outstation, the legal practitioners, their practice at time. However, if you look at the debt recovery law, action can be filed under the debt recovery law on 3 grounds: residence of the dependent, and the place where the contract was entered into, and the course of action rules. So the ground that residence of the plaintiff is not included. The value of the action has to be more than 150,000 rupees. And then we'll go to the section 4 of the Act number 2 of 1990. Now, action under the debt recovery law can be filed in relying on an agreement or instrument. And thereafter, action is filed by filing a plaint. Along with the plaint, you have to file an affidavit certifying that money is lawfully due to the bank. And the difference is, in a regular action, a judgment will be given only after the conclusion of the full trial. Under the debt recovery law, difference is a decree nisi will be entered at the outset. That's the difference. That's where the legislature gave additional leverage to the banks and the finance companies. So what is the legal effect? As we go on, we will understand. Legal effect is the dependent has to show force against the decree nisi by obtaining the permission of the court to even to appear. So you will see the difference. Under regular procedure, judgment can be given only at the end of the day. Here, a decree is entered in favor of the financial institutions and the banks at the outset. In order to obtain a decree, as Section 4 requirements, agreement in writing, affidavit that money is lawfully due, and affidavit signed by a principal officer must be there. Then, if the court is satisfied ex specie, those requirements are compliant, and the agreement you are sued upon, of course, is not open to any suspicions. Then the court will issue a decree nisi at the outset. So I have set out, refer to section 50 of the CPC, where we are supposed to file an original document if we sue upon the document. However, under the debt recovery law, you need to file only the copies, and the original will be shown to the judge and returned to you as per section 8 of the Act once the decree nisi is entered. Those are minor changes, or rather differences we have to understand. Then, this is what I said, judgment is conferred at the outset. Now, once the judgment is, the decree is entered, it has to be served on the other party in the manner as set out in the section 5 of the Act, that you all can go to the Act and see. Basically, there is an important aspect. Under the debt recovery law, if you are retained to appear for the defendant, on the decree nisi returnable day, you have to make an application for leave to appear. And no time will be enlarged as per section 5 of the Act number 2 of 1990. Normally, we go to court, file the proxy and ask for the date to file the answer. It is not permissible here. So if we are appearing for the dependent, we have to safeguard rights of the dependent. We must be ready with the papers. So now decree is entered. What is the next step? It is served also under section 5. Then there is a sui generis procedure set out in the section 6 of the Act number 2 of 1990. That is where there are a lot of litigation. Once a decree nisi is entered, in order to appear and show cause. In a normal action, as a right, you are entitled to appear and file a proxy and contest the case of the plaintiff. Here, even to appear, the defendant shall not appear or show cause unless he obtain the leave from the court. So, when you are filing the papers under section 6, you have to make an application for leave to appear and show cause in writing, supported by affidavit. Such an application must set out prima facie sustainable defense. What is the prima facie sustainable defense? The legislature has stated that word, court has interpreted that. In short, there are 100-odd judgments on this point. Prima facie sustainable defense means it is not a defense simply say, I owe nothing. You have to refer to the claim, refer to the statement of account, and give in a summary manner as to why you are not liable to pay this money. And set out in a summary manner to the court that yes, look here, the plaintiff bank is asking 100,000, 200,000. I have paid this money. And in several judgments, it has held that mere technical objections are not permissible. බොහෝ වෙලාවට අපි ගන්නවා නඩුව කාලාරෝධය වෙලා. ඒ වගේ දේවල් තමයි බොහෝ වෙලාවට කියන්නේ. ඒවා මේ අනතේ ප්‍රතිපාදන ප්‍රකාරව පිළිගන්නේ නැහැ. ඊගන්න එකම දේ තමයි හරියට මුදල් ගෙවලා තියනවාද නැද්ද කාරණේ තමයි කියන්නේ. So then this section 6 has a 3 limit. 6.1, 6.2 and 6.3, and rather under the section 6.2, 6.2a, 6.2b and 6.2c. When I meant section 6 has 2 limb, basically it is section 6.2 has a 3 limb. Section 6.2a, section 6.2b and section 6.2c. When an application is made by the defendant for leave to appear and show cause, court can make 3 orders. If the court is not happy about the defense, court can ask the defendant to pay entire money as set out in the decree NISA. 6.2a. Then the 6.2b, court can order security for leave to appear and show cause. 6.2c is the provision the court was given some discretion regarding leave to appear and show cause. If there is a prima facie sustainable defense, the court can decide the amount of the security and give leave to appear and show cause. Recent judgment has stated that, even I cite this Chemical Sales Holding Limited versus People's Bank, decided on the 3rd April 2025 by Justice Samyavardhana, and also Justice Priyantha Jayawardena. There is a judgment reported in 2021, 3 SLR page 1. All those judgments now state that if there is a prima facie sustainable defense, the defendant should be allowed to even show cause unconditionally. So we'll have to understand section 4, decrease entered. Then the section 6, application for leave to appear and show cause is given. And so once the leave to appear and show cause is granted, the manner the action should proceed is set out under the section 7 of the Act number 4 of 1990, rather 2 of 1990. Now you can see it make a reference to the several provisions of the CPC. Section 7 හතෙන් 7 වෙනි වගන්තියෙන් සිවිල් අනුවිධාන සංග්‍රහයට මේ දෙක ඉන්ටර්කනෙක්ට් කරනවා. ඒ ඉන්ටර්කනෙක්ට් කරලා leave to appear and show cause grant කරාම විමසීම ඉන්ක්වයරිගේ යන ආකාරය සිවිල් අනුවිධාන සංග්‍රහයේ 384 385 386 387 යනාදී වගන්දී ආකාරයේ සිදු කරන්න ඕනයි කියලා තියෙනවා. So what is the legal effect of that? Legal effect is, if you look at the section 384 of the CPC, the defendant must start the case. So in a regular action, plaintiff will start the case. Here, once the leave to appear and show cause is granted, defendant should start the case. Then, defendant has to read the affidavit in evidence, section 384 of the CPC. And with the permission of the court, lead oral evidence with the permission of the court. So what happened, if the permission is given as per judgment of Justice Samyawardana to lead the oral evidence, the plaintiff can even cross-examine. Then it refers to section 384. Once the evidence is the defendant is over, it is not in these slides. The plaintiff can comment upon the case of the defendant. Then under section 386, he can move the court to, the plaintiff can move the court to lead oral evidence or file an additional affidavit on behalf of the plaintiff to counter the stance taken by the defendant. So you will see, then thereafter, under section 389 of the CPC, the court will make a final order. Court will make a final order whether decree nisi should be made absolute or not. So, see, that is the difference from to the regular procedure. So then, when we are appearing for the banks or for a dependent, we must know this procedure. So initially, action is filed. If I may repeat, you make an application for leave to appear and show cause under section 6. The court grant it, go to a section 7, read with section 384 onwards of the CPC. So there, under the summary procedure, under chapter 24 of the summary procedure, the case will be decided and the final order will be made. So that's a difference to a regular procedure. Now I have referred to this Kularatna versus People's Bank. It is reported in 2001. One SLR also, you can make a reference to that. Now, under the debt recovery law, if you abuse the process of debt recovery law, the court can award the damages. Because debt recovery law, one might say, is a draconian in nature. Once a decree nisi is entered, it will curtail your ability to deal with your own properties. Decree nisi එකක් enter කරාට පස්සේ මේ පනතේ ප්‍රතිපාදන අනුව විත්තිකාරයන් මේ 15 දේපල වෙන පුද්ගලයෙකුට පැවරීම යනාදී කාරණා කරොත් එහෙම ඒක ඒ පැවරීම කිසිදු වළංගුතාවයක් නැහැ කියලා සඳහන් වෙනවා. So if there is any alienation of immovable and movable property after decree nisi is entered, those alienations and the dealing with the property are null and void and no force or effect in law. So therefore, it's a evasive of rights of the debtor. So if the court is moved and plaintiff obtain a decree nisi by suppressing the material fact or non-disclose of material fact, the court, if it founds that there is such a scenario, it will award the damages under the section 11 of the Act number 2 of 1990. Now, section 12, since we all are appearing and we all are keen about the settlement, section 12 permits the parties to adjust the action without contest. That is, basically, you allow the defendant to liquidate the debts in installment. That is to say, a decree will be made absolute. However, the defendant will be permitted to pay the money in installments rather. That is to liquidate the debts in installments. That's the section 12. Then the interesting section is section 13. Now, ordinary civil action, when we obtain a decree or judgment, we have to file a formal paper in the form of decree in the courts, signed by the judge, then only we can move for execution. However, under debt recovery law, once the decree nisi is made absolute, it will be made on the initial decree itself by making an endorsement by the judge. So once the decree is made absolute in such a manner, it deemed to be a writ of execution. It's deemed to be a writ of execution issued to the fiscal as per section 225 subsection 3 of the CPC. So section 225 subsection 3 is applicable for a money decree. That is to say, fiscal is directed by the judge once he make the decree nisi absolute, or he is given an order, go and execute the writ. So as per the law, decree absolute is valid for a period of 3 years, and notwithstanding any other law, the writ of execution will be carried out. When a නීතියක මොනා තිබ්බත් අවුරුදු 3කට වළංගු වෙන මේ 13 එක යටතේ ඉෂුව කරන writ of execution එක ක්‍රියාත්මක වෙදීම නවත්තන්න බෑ. તો නවත්තන්න ඕන නම් මහාධිකරණයට ගිහිල්ලා තහනම් නියෝගයක් ගන්න. දැන් ඒකේ legal effect එක තමයි බැංකුවක් finance institution එකක් මේ පනත යටතේ නඩුවක් පැවරුවොත් එහෙම decree absolute හම්බුනාට පස්සේ they don't need to make an application for writ pending appeal under section 761 and 63 of the CPC. Usually, if we get a mortgage decree or otherwise, we make an application for writ pending appeal. Appeal එක පවතින තුරු අභියාචනයේ පවතින තුරු අපිට තීන්දුව ප්‍රකාශය ක්‍රියාත්මක වෙනවා. None of those provisions are applicable under debt recovery law. So those position has been confirmed by this Ceylon Bank versus Rasik, and also this Dharmavansa versus People's Bank. And these are the we will have to now the manner a writ can be executed. You see that earlier section 30 referred to a section 225 of the CPC. When the fiscal is directed to execute the writ, though there may be a mortgage, there is no mortgage decree. How we should execute the writ? So what we do, you identify the property and register priority seizure notice and or seizure notice under section 237 of the civil procedure. So that is how you execute any money decree. If you have a money decree in your favor, however, if there is no mortgage, what you do, you look for the property or assets of the dependent. If you find something under the section 237(1) of the CPC, you registered an instrument called priority cession notice or cession notice under the registration of document ordinance in the land registry. So that gives the priority for you to seize the property in execution. And thereafter, the manner that it should be registered is set out in section 238 of the CPC. Now, I have made a brief reference to section 50. Now, if we obtain a money decree in the normal course of the proceeding under the civil law, if someone wants to make a claim in respect of any property seized in the previous section, a third party, he has to make a claim. As we all know, claims cannot be made by the judgment debtor. No claim by the judgment debtor. Civil Law විධාන සංග්‍රහයේ 241 ඉඳන් 247 වෙනකන් තියෙනවා කොහොමද property එකක් seize කරාම ඒකට claim එකක් කරන්න කියලා. ඒ claim එක කරනකොට විත්තිකාරයාට claim එකක් කරන්න බෑ. Naturally, those are his property. However, third parties under regular procedure can come and make a claim under section 241. Then the court can make an order under section 244, 245. Then either release or refusal to release the property. However, under debt recovery law, if any property is seized, you have to make to the claim not under section 241 of the CPC, but under the section 15(5) of that number 2 of 1990 to the same court. To the same court. Now, assume that a money decree is issued by the DC Colombo executed in Avisarial. Usually, as per the CPC, a claim can be made at DC Avisarial. However, when it comes to the debt recovery law, no, you have to go to DC Colombo to make the claim. There are many council, even president council make that mistake. They make a claim under 241, no to the, yeah. Now I have, these are already I have stated, 763 has no application, and notwithstanding any other written law, it must go. So, now last year, the legislature enacted Act to punish for the people for contempt of court. One of the things found in this new law, which was enacted in the last year, a willful disobedience to a decree can be punished as a contempt of court. However, if you look at the section 14, way back in 1990, by giving a leverage to the financial institution, the legislature gave the power, even in the case when you are executing the writ, if there is a resistance, that deemed to be a contempt of court. These are the instruments. If we are appearing for the bank or financial institution, we can use effective. If you resist, it deemed to be a contempt of court. You can be, you see, you can be fined and you can be imprisoned also. Not for a period, not more than 2 years. There's a point lesser than 2 years period. So those are penal provisions, a combination of penal provision and the civil law provisions. That's why I say these are sui generis enactment enacted to facilitate the recovery process. This is similar to the action under 247. Under CPC 247, you make Polian action, you file the Polian action to get the property. This is similar. If the after decree I enter, if you dispose the property, then those also have no validity in law. We would have never thought a civil law, civil enactment has this sort of provisions. Those are very wide power given to the companies. Then I have dealt under section 16 about the appellate procedure as to how appeal can be filed. Interesting thing is, if the court of appeal decided to grant leave to appear and grant leave to appear, if I would say grant permissions leave under the section 16, the court has to award the security for the purpose of possible execution also. So even though leave is granted, the proceeding in the lower court shall not be stayed, and also if the court of appeal grant the leave to appear and show cause, it has to order security in cash, show, or bank guarantee. Why cash or bank guarantee? To enable the plaintiff to recover the money at no time. That's the purpose of awarding the security in the form of cash or bank guarantee. You will see the difference from the many other provisions of the law. So, the Ceylon Bank versus Mohammed Little Rasi, Justice Shiranithila Kawardana held that once the declaration is made absolute under section 6.3, at the initial stage, not of the section 7 inquiry I adverted earlier, leave to appeal does not lie, it's a final appeal. Now we have to file up. Now this is interesting. So the money lending ordinance and debt conciliation ordinance, which were meant and which were in existence from long time, this money lending ordinance was enacted, if my memory is correct, somewhere in 1908. Those enactment had certain provisions, like you can't recover interest in excess of the capital. When it comes to the debt recovery law, those provisions have no application. And also, there are two important things you also can keep in mind. That is rate of interest. There is a debate going on. What is the correct law regarding the rate of interest? Now in the Supreme Court also, there is a Justice Janagni Silla's judgment. You may read the 2004 BLR, we have reported that. Also, this year in March, Justice Amarasekara delivered another judgment, analyzing the section 5 of the civil law ordinance and the interest payment. We have to read this judgment of the Supreme Court to understand if we are practicing this civil law. Justice Amarasekara's judgment delivered on, I think, 5th March 2025, he has, of course, hinted that the privity of contract must be given effect when awarding the interest. He has referred to section 192 of the CPC, where it has given a provisions and set out the manner as to how the interest should be calculated. So this debate is there because one segment of the society, namely lenders, may try to enrich at the expense of another poorer segment of a society. That's why section cap the section 5 of the civil law ordinance that money in excess of what you lend cannot be recovered. There is a clause like that. However, debt recovery law say that has no place under the debt recovery. When it comes to our civil litigation also, as per Justice Janagni Silla's judgment, at the time you file the action, your plaint cannot contain money or you can't rather pray for money in excess of the money you lend. If you lend 100 rupees, rupees 100 දෙනවා 200ට වඩා පැමිණිල්ලේ ඉල්ලන්න බෑ. ඊට වඩා පොලි ඉල්ලන්න පුළුවන්. rupees 200ක් ඉල්ලනවා rupees 100 මුල් හිඟ මුදල මත පොලි ඉල්ලන්න පුළුවන්. Then at such a scenario, Section 192 of the CPC is applicable because if there are litigation pending for a long period of time, the rationale is the plaintiff should not be permitted to suffer because of that. Then, therefore, interest has been permitted as per section 192. Similarly, section 23 of the debt recovery law, we have this question. Always, if there is agreement, you are entitled to charge the interest as per the agreement. Then, if not, market rate as specified by this act. Market rate is specified under the interpretation section, namely section 30. So you will see those are the main thing when it comes to the debt recovery law in summary. Penal procedure, penal procedure section 25. I know our senior counsel, Mr. Aravind Dias, must be using this section 25 very frequently to file action in the magistrate court. That is where you go check, knowing that there are no funds, it has been made a criminal provision under this Act number 2 of 1990. It applies across the board, not only for the banking transaction, as per judgment, majority judgment of the Supreme Court, delivered in the year 2006, I think the Solis case. Solis case, now latest judgment on the debt recovery law. Chandrasekhar was Indian Overseas Bank. He appeared for the bank. There was a nagging question, when there is a mortgage bond, can the bank file the debt recovery actions? There were many counsel who was of the view that when there is a debt mortgage bond, you must file a mortgage bond action. However, in this Chandrasekhar versus Indian Overseas Bank, there are two key findings. One is when, having regard to section 30 definition of the Act number 2 of 1990, the Supreme Court Justice Abhaysekhar held that even though there is a mortgage bond, you can go for a debt recovery action. The second matter in that judgment, there was a mortgage bond to secure the repayment of 85 million granted by the bank. Then, for the first time in the Supreme Court, the defendant moved the court to accept the security mortgage already given to enable him to show cause against the decrenizer. The Supreme Court said, rather held, such a procedure is possible in the district court. So if you have given a security in the form of mortgage, of course, you can move the court to accept the same as a security and permit you to leave to appear and show cause. However, the defendant must satisfy the value of the mortgage is sufficient for the satisfaction of the decree at the end of the day. So you will see that's a new finding thinking by Justice Abhaysekhar. So that goes to the previous finding that when they are now, the Supreme Court now, this Chandrasekhar judgment, chemical holding judgment, and also this Justice Priyanta Jayawardana's Farooq judgment, they have moved to the thinking that under section 6, if there is a prima facie sustainable defense, the defendants must not be asked to deposit the money again and now give another security, but they can rely on the security already there. And ordering a security again is unjust. That was the view of the Supreme Court. So now we see even the legislature has provided that certain provisions of law, Supreme Court has interpreted them, striking a balancing act, I would say. So those are the things I want to speak about the debt recovery law. You can go through the slides. So I'll briefly explain what is this Parate Execution Act number 4 of 1990 all over. Now, until 1990, banks or anybody can impose a mortgage bond by going to the courts. When it comes to the loan transaction, there are two parties, creditor, debtor. Then there is a security. Some facilities may be secured by a mortgage, some are not. When the facility is secured by a mortgage, given in favor of the, now as per the law, licensed commercial bank, licensed specialized bank, they can avail the Parate execution. That's the substance. These are the institutions who have been permitted to avail the Act number 4 of 1990 along with the licensed commercial bank and the licensed specialized bank. People's Bank, Bank of Ceylon, NDB, they were given the power by their own enactment to go for a Parate execution. It's very much similar to the, identical to the Act number 4 of 1990 with certain modifications. Now these are the amendment made to the Act number 4 of 1990. By 1 of 2011, the limit was brought down to a 5 million. Rather, ceiling was set up of 5 million. After enactment of Act number 1 of 2011, if the capital outstanding is less than 5 million at the time of the default, you can't go for a Parate execution. And the main amendment after 1990 is the Act number 1 of 2011. Section 5A I have referred. Now, what is the scope of the Parate execution? In this judgment, Justice Tilakavardhana, Parate execution is there to enable the bank to recover their money. However, process must be conducted in a fair and reasonable way. You see what the Supreme Court has said, that there has to be a balancing act. Let the banks eat their cake, however, in a fair and reasonable way. So if the banks acts in excess of the power or unreasonable manner, the court has not been reluctant to exercise their power. This is what I meant earlier. Who can avail the Parate execution? Licensed commercial bank. Then after the Act number 1 of 2011 was enacted, the licensed specialized bank. So, Parate execution process can trigger only after default. What is the default? Default is defined as a failure to repay the money borrowed, principal or the capital. Poliye ගෙවන Parate execution යන්න පුළුවන් කියලා මේ section 3 එකේ සඳහන්. These are deeming provisions. Whenever default is made in the payment of any sum, on the account of whether on the account of principal or interest or both, default shall be deemed. You see, in our law, when we are learning the law, we understand there are certain provisions called deeming provisions. Now, this is a deeming provision. Though you have defaulted only the interest, default deemed to have been made in respect of the entire facility. Then, in such a scenario, the board of directors of the bank can act under the section 405 of the Act number 4 of 1990. 4 means the bank adopt the resolution to sell the property. 5 means the bank allow the bank manager or authorized person to come into the property, manage the property, recover their money and return the property. Twofold. One is to sell, section 4. 5, allow the authorized agent or manager to come into the property, enter the property, maintain the property, recover its money and return the property. So it's twofold. Then, once the resolution is adopted, bank has to publish it under Section 8 in the government gazette and the newspapers. Then thereafter under Section 9, they have to publish it again before the sale in the government gazette. Copies of the both the publication must be served on the person who obtained the loan, borrower, and thereafter, once the sale is conducted, a certificate of sale will be issued. The legal implication of certificate of sale is akin to a similar to a deed of transfer. Title of the person, the borrower, is transferred by this legal process to the bank or the person who purchased the property. The banks have been permitted to purchase the property only for limited purpose of reselling the same in the open market. The bank can't keep the property for itself. However, third parties can purchase the property, then they have to buy the property for the price set out in the Section 11, that is a price not below the upset price. Section 11. So, once the property is sold, almost all the mortgage properties are encumbered with the occupant. Accordingly, application can be made under Section 16 to obtain a delivery of possession in the summary procedure to the district court where the property is situated or to the DC Colombo. Then the Section 17 say, even after the property is sold, if you pay the money, at the request of the debtor, the property can be, the certificate of sale can be cancelled and property will be vested again as if there was no sale at all. Those are the wording in Section 17. So this is what I indicated earlier. Once the property is acquired by the bank, it must resell within a reasonable time. So after sale of the property, if there is excess money, if you read the Section 14 of the Act Number 4 of 1990 and 13 of the Act Number 19 of the Act Number 4 of 1990, excess money must be paid to the customer if there is a surplus. Then the Section 10. Once the resolution is adopted, if the customer wants to pay the money, if he pay entire money with the cost and other amount recoverable under Section 13, the bank shall not go ahead with the auction. However, only the overdue loan installment, installment then the bank has option either to go ahead with the auction or not. You see Section 10, A has a two limb. A, you pay everything. Bank can't go ahead with the auction. B, you pay only the installment. Then bank has an option to go ahead with the auction or not. So these are upset price I spoke about earlier. Then the Section 13, it has set out what are the money recoverable under the parate execution. You can recover naturally the loan granted and the interest. Thereafter, you can recover whatever the expenditure you have to bear in publication of the notices and the newspaper, etc. And the insurance premium and everything can be recovered together with the cost of advertisement, etc. So the legal implication. Once the certificate of sale is issued under the parate execution law, the borrower cannot maintain any right, title, interest to the property. කිසිදු අයිතිවාසිකමක් පවත්වාගෙන යන්න බෑ. සහ කිසිදු උසාවියක he cannot move to invalidate the certificate sale for any reason. කිසිම උසාවියක නඩුවක් දාලා එය අවලංගු කරන්න බරවට හැකියාවක් නැහැ. සල්ලි ගත්ත පුද්ගලයා. Then this Hajji Omar Vikramasinghe, Amardas Eliyanage, Sampath Bank, those are the judgment dealt with that point. This is what Section 16(1) I indicated earlier. This HNB versus Gunatilaka, in this judgment, the procedure followed in section 16 application is set out. No right of appeal. In the ordinary course of the business, after judgment, as per the provisions of the section 23 of the Judicature Act, any aggrieved party has a right to appeal to the superior courts. Now with the civil appellate high court, or if it is a commercial high court, Supreme Court. However, under the debt recovery law, rather under this Act number 4 of 1990, no right of appeal. No appeal. Because this is a special law, no right of appeal is specifically provided by that. As you know, Martin was a Jayawardena, Justice Jamil judgment, it is stated that if any enactment does not state specifically there is a right of appeal, special law, when it comes to special law, no right of appeal is permissible. This is a balance of the sale proceed under section 14, which I have mentioned earlier. This is section 17, you can slowly go through. Then the third party mortgage. Then the third party mortgage is under section 4, 3 and 4, bank is entitled to sell any property mortgage with the bank. The any property mortgage with the bank was the center of many arguments. Many contended that property mortgaged by a person other than the borrower, the third parties cannot be sold by party execution. So, this initial stage, the judgment, the Court of Appeal has said no, it is possible. However, is the Ramachandran versus Hatton National Bank, Justice Sarathan Silva, Chief Justice, majority decision held that third party mortgage properties cannot be sold by way of party execution. Now, in relying on that, enjoining orders and interim injunction was obtained from time to time. The Ramachandran case was, of course, distinguished by the HNB was Samatapala Jayawardena, Justice Nihal Jayasingh's judgment as reported in 2007, one is set up page 181. Now, this debate was into rest by the judgment of Supreme Court of 7 judges in the year 2020. This is Sunpack Engineering Private Limited, was a DFCC bank. With that judgment, Supreme Court has held that in a very categorical manner, any property means property of the borrower as well as the any third. So you will see that is how the debt recovery law regime regarding the bank and the financial institution are concerned are applicable. What we have to understand when a client comes to us seeking our advice, we have to ascertain so the nature of the transaction. Is it related to a bank or financial institution, or is it a ordinary money lending action, money lending transaction between the private parties? Depending on that only, we have to set up or identify our course of action. If a customer or the client come to us obtaining with the mortgage bond given by a neighbor, we can't avail the party execution law Act number 2 of 1990. Then we have to file an action under the mortgage act, where we have to file action, file a spenders, declaration under the hand of attorney at law, certifying the encumbrance in the land registry, and go on to the trial and obtain a decree under the mortgage act. That is to pay the money. If you don't pay the money, after 2 months period, property will be sold. However, if another customer comes to us, bringing a check or promissory note, then we'll have what is the remedy under chapter 53 of the CPC, file a claim. Then that's how we identify the course of action. However, if I have given some money to my neighbor without any written document, I can't avail both the procedure as I adverted a moment ago. Then we'll have to file a regular money action. Then this is the procedure applicable to the banks and the financial institutions. So those are the procedure then generally applicable to the debt recovery law in Sri Lanka. Quite apart from that, there are small claim courts. Then we'll have to think about the Mediation Board Act. Then Debt Conciliation Board is there. So some transaction, the nature of the transaction, whether it's a mortgage or the transfer, that will be decided over there. Then what else? Those are the basic things you must know when it comes to debt recovery. If you have any question, I am prepared to answer. I'm sorry, it's Sunday morning, easy Sunday, we are not supposed to learn, but sorry to bother you with this. If there are any question, I am prepared to answer. That's all I can say.
Thank you, sir, for that interesting and thought-provoking lecture. I would like to invite Mr. Pasundu Silva, the Treasurer of the Bar Association of Sri Lanka, to present the token of appreciation to Mr. Alagiyawan. We are privileged to have you with us today. Ladies and gentlemen, before we proceed to the final technical session of this symposium, we will proceed for a break. Please enjoy some refreshments and check out from your respective rooms, and we will convene in 30 minutes for the final session. Thank you. See you at 11:15. He assumed duties as the Director General of the Commission to investigate allegations of bribery and corruption in January 2025. He was an attorney at law of the Supreme Court since 2000. He holds a master's degree in law from the University of Colombo. He, beginning his judicial career in 2005 as a magistrate, he has served in various courts across the country, including as Colombo Chief Magistrate in 2018 and later as a High Court judge in Monragala, Balapitiya and Negombo. Dear sir, the stage is yours.
Thank you very much for the introduction. And Mr. Rajiv Amarasuriya, President Bar Association of Sri Lanka. I would like to invite you come close to me here because there are a lot of spaces here. Because first of all, I would like to thank Mr. Amarasuriya giving this opportunity to do this presentation for you as a Director General of Symposium. As you know that my career started as a magistrate from Magistrates Court Kantale. I am very happy to see that some colleagues here from Kantale courts, Magistrates Courts, and after serving various Magistrates Courts as a magistrate, and I elevated to the High Court in year 2020. My role has changed after I appointed as a Director General. Now, my role is the prosecutor's role. Other than Attorney General, the Director General is the only person who can file indictments before the High Court. So, first I would like to know about the composition of here. What are the fields of yours? Who are practicing criminal law here? Yeah. Especially that I think is practicing lawyers who are doing criminal practice. That most of criminal lawyers very well known about me because in my career I worked as a magistrate and High Court judge last 20 years. Some period of time as a district judge. I would like to say this. Now, according to my information, what I gathered, I was very famous and favorite judge of the lawyers. Yes. There's no conflict ever that in when I worked as a judge, no conflicts with the lawyers. Right? Here I have evidence for that to prove. The reason was I am given ample time to do the lawyers to do their applications. Like what the lawyers want, they won't give hearing, the proper hearing by the judges. Another thing I like, if the lawyers doing new applications, what said new applications means, now you know that in practice in our course, most of lawyers doing same things, some same applications. But I like if someone lawyer is a junior or senior and raised an make an objection or make the new thing, the law, new area, I like it. But recent past, some lawyers considered I am as an enemy. Right? But I understand why is that. What is the reason? Not actually against me also, the bribery commission as well. But I understood the reason was the lack of knowledge. That's why I thank again to Mr. Amarasuriya for giving this opportunity to educate you and to explain you what we are doing. Lawyers think that we are exceeding our powers, the bribery commission. When you are practicing Colombo, you can see some lawyers criticized. They are criticizing the bribery commission, the way of doing bribery commission. I think the reason is the lack of knowledge. The most of lawyers know the general law, general criminal law. But when the special law enacted and introduced by the legislature, that is the law of country, not the law of CFO or law of the Director General of Bribery. That is the law of the country. I will ask this question, right? Other thing, this is should be the interaction session. If you want to put any question in Sinhala, it's okay. And I am also can explain some stories in Sinhala than in English. So, have you read the Anti-Corruption Act? Anyone of you? කවුරු හරි කියවලා තියෙනවද? Anti-Corruption Act කියලා එකක් තියෙනවා කියලා දන්නවද අඩුම තරම? Right. All of you know about the bribery, right? හැමෝම දන්නවා bribery ගැන. සමහර වෙලාවට bribe දීලත් ඇති. Be honest. Be honest. When you are working in courts, I know without giving bribery, you can't do anything. You can't take the certified copies. You can't take the files to peruse. Right. And I would like to say, offering the bribe also an offense. Right? Nowadays, the thing is this. All are against corruption. මට corruption වලට කැමති මිනිහා හොයාගන්න බෑ. Right? Everybody. When we ask, මෙතන යවුවොත් කවුද හරි ඉන්නවද corruption වලට කැමති අය කියලා? All are anti-corruption. Right? ඒ කියන්නේ ලංකාවේ රිසර්ච් එකක් කරොත් corruption වලට කැමති අය ඉන්නවද කියලා අහන්න කවුරුත් නැහැ. ඒ කියන්නේ හරිනම් සිය බොක් එක වහලා දාන්න පුළුවන්. But the reality is not that. Reality is, I could understand actually this reality as a judge. But after I assumed duties as a Director General, now I know very well what happened to this country. How that economic crisis came, right? I would like to explain that to you and the importance of this law. This is the highly recognized piece of legislation by the international community. It's in line with the United Nations Anti-Corruption Convention. Very standard law, but very unfortunate thing is, like some other acts passed very recently in Sri Lanka, because I always criticize in this, the process of making laws in Sri Lanka. You know, there is now the present act, present laws, bulky laws. Here, this is the Sinhala and English one. This is the Proceeds of Crime Act. English and Sinhala both, right? How big is it? Right? I'm not, right? We see that it's a comprehensive one, right? But how many sections in the evidence ordinance? How many sections? 165 sections, right? In whole evidence ordinance from 80s, from 82, I think, or something, right? All evidence, law of evidence covered by just 165 sections. So what happened to that? These acts now passed by our parliament. In Sri Lanka, now they are trying to make the most comprehensive and that most standard act in world. But sometimes, in practically, when we are implementing that, there are a lot of issues, right? But we will get that positive side of that, and this is a contents of my lecture, my presentation. This is a vast area. I can't cover actually that. What is the time period allocated for me? 1 hour. 1 hour is not enough to actually change my slides as well. But yes, I will give you the outline, right? So this is the contents, the evolution of the law related to bribery, and I would like to give some idea about the United Nations Convention Against Corruption and Anti-Corruption Act. So this is a bribery. Bribery actually, statutory offense of bribery was conceived in the Penal Code Ordinance in 1883. Right, there are the sections in Penal Code related to the bribery offense. And Bribery Act enacted 1954. I will move fast because of the time constraint. This is the amendment of 1994 20 of 1994. Especially, I would like to tell about this section. Section 70 of the Bribery Act. In the similar section, the similar offence is in 111 of the Anti-Corruption Act. Right. Please take your phones. And do you have a internet now? You can go. Right. Please search the corruption word. Word of corruption. What is the interpretation? This is a general word. General, that means general meaning of that entire word. Corruption. That's general meaning for the corruption. Right? Yes. Abuse of power actually. Yes. Yeah. That is the general interpretation. කවුරු හරි අපි අහුවොත් දූෂණය කියලා ඔයගොල්ලෝ දන්නවනේ පරිසර දූෂණයක් දූෂණය. What is this? ලංකාවේ I think it is architecture of this section is Professor GLP is වෙන රටවල නැති corruption නමින් offense එකක් තියෙනවා. වෙන රටවල නැති bribery is an offense, a worldwide offense. But corruption is a general meaning. But corruption කියලා offense එකක් තියෙනවා ලංකාවේ විතරක්. මේක තිබුණ නැත්නම් දැන් මම කරන කිසිම දෙයක් කරන්න බැරි. මේ වෙනකොට කරන. Right? This is the same section included to the Anti-Corruption Act, section 111. Right? Here, section 70. Any public officer who with the intent to cause wrongful or unlawful loss to the government or to confer the wrongful or lawful benefit, favor, advantage himself or any person. Right? And there is a section by using his official capacity. And you can see, second one says, includes any other public officer to perform or refrain from performing any act which such other public officer is empowered to do by virtue of his office as a public officer. Induces. Right. මම මේක මෙහෙම කියලා දෙන්නම්. මෙහෙම තේරෙන්නේ නැහැ මේක. දැන් මම Bribery Commission එකේ Director General. Under section 18 of the Anti-Corruption Act, I am the Chief Executive Officer and I am the Chief Accounting Officer of the Bribery Commission. Right. මට Bribery Commission එකෙන් ෆෝන් එකක් දීලා තියෙනවා. ආණ්ඩුවේ සල්ලි වලින්. සල්ලි එන්නේ පාර්ලිමේන්තුවේ දීලා තියෙනවා. මම අවුරුදු 5 that is according to the Anti-Corruption Act, the period is only 5 years, can't be reappointed. Only for the 5 years. Right. එතකොට හිතන්න මම මේ අවුරුදු 5 ඉවර වෙලා යනකොට මේ ෆෝන් එක ගෙදර අරන් යනවා. මම මේ ෆෝන් එක ගෙදර අරන් යනවා. මම කරන ඔෆෙන්ස් එක මොකද්ද?
රාජකාරී කෝල් එකක්.
නෑ මම මේ ෆෝන් එක ගෙදර අරන් යනවා. මම ආයි බාර දෙන්නේ නැතුව මට Bribery Commission එකේ පාවිච්චි කරන දීප එක මම ගෙදර අරන් යනවා. After 5 years මම තනතුරෙන් යනකොට.
Corruption.
What? What? Offense? What is the offense?
Misuse.
What is the offense? No. ආණ්ඩුවේ මිනිහෙක් ආණ්ඩුවේ තමයි දීපු දේ ගෙදර අරන් ගියාම ඒක මොකද්ද? What is this? What is this? Public property. Right. Misuse of public property. What is that offense? Where is that? Yes. Under Section 5 of the Public Property Act, misappropriation of public property. Right? පොදු දේපල සාපරාධී සාවද්‍ය පරිහරණය. හරිනේ? That is the criminal offense that I am doing individually. That is an individual act. කවුරු හරි මේක ගෙදර ගෙනිච්චොත් එච්චරනේ. හරි? ඊට පස්සේ 25,000 වලට වැඩි නම් certificate එකකුත් දැම්මොත් exceptional circumstances ඕනේ under the section 8 of the Public Property Act bail ගන්න. Right? හැබැයි මම මගේ අර chief executive officer and chief accounting officer කියලා මට බලයක් තියෙනවනේ. හරිද? ඒක පාවිච්චි කරලා මට ඒක එහෙම ඕන විදිහට පාවිච්චි කරන්න බෑ. මම ඒක පාවිච්චි කරලා ආයුතු ලෙස intent to cause wrongful or unlawful loss මම circular එකක් ගන්නවා. bribery commission එකෙන් යන හැමෝටම අස්වැල යන හැමෝටම Tamanට ආණ්ඩුවෙන් දීපු ෆෝන් එක ගෙනියන්න පුළුවන්. එතකොට ඒ ගෙනියන පුද්ගලයා public property act එක යටතේ වරදක් කරනවද? නෑ. හරිද? ඇයි මං සර්කියුලර් එකක් ගහලා කියනවනේ ගෙදර ගෙනියන්න කියලා. හැබැයි කවුද වරද කරන්නේ? That is a different of the corruption and the criminal misappropriation of property. Right? Can you understand? ඒ නිසා තමයි දැන් තියෙන ඔය ඔක්කොම දැන් තියෙන නඩු ගොඩක් ඒවට ඔක්කොන්ටම government policies සමහර ඒවා government decisions cabinet decisions ඔක්කොන්ටම තියෙනවා. Right? But with the corrupt intention හැම cabinet paper එකක්ම එහෙම වෙන්නේ නැහැ. If you take that decision in good faith, no offense committed. But with the intent to cause wrongful, unlawful, there is a thing intent, and again it says with knowledge. The mens rea is not only intention here, this section, knowingly. Right? ඒක තමයි සමහරු කිව්වේ මේ ළඟදී මහින්දානන්දලා කැරම් බෝඩ් ගෙදර ගෙනිච්චේ නැහැ කියලා. Right? හැබැයි cause wrongful or unlawful loss to the government. Yes, benefit has not been proved that case, but its loss has been proved. Right? Enisa, I have to thankful to Professor J.L. Firis to introduce this type of offense. Otherwise, the past governments of Sri Lanka, I don't know what happened to the future, but fortunately 111, section 111 on also exists in our anti-corruption act, right? You can't do anything, right? You have a power, but you can't do anything. You have to do in good faith. Otherwise, this is the one can interpret this as a abuse of powers, right? If not this type of offense, that is only remedy is a writ jurisdiction, ultra vires. But this is an offense. You have to go jail, right? So I want to emphasize that only this section, because there is some. Then මේ මෑතක ඉඳන් මට තරහකාරයෝ වැඩි වෙන්න හේතුව තමයි the commission, the bribery. I will explain that after that, when that bribery commission established, and after that I will explain that. මට තරහකාරයෝ ඇති වුණේ කොහොමද කියලා කියන්න. Right. 1994, by Act Number 19, 1994, the Commission to Investigate Allegation of Bribery or Corruption established. That is the way of establishing the bribery commission, that so-called bribery commission. This is a convention, UNCAC, we call United Nations Convention Against Corruption. This is a only one international convention regarding the anti-corruption. Right. There are 191 state parties. We signed to this convention 15 March 2004 and ratified 31st of March 2004 into force 14 December 2005. But since 2023, until the 2023, we haven't had the comprehensive anti-corruption law in this country, in line with the UNCAC. In 2023, this act passed by the parliament. I will show you the preamble. It says why that act passed by the parliament. Repeal 3 acts. Bribery Act, Commission to Investigate Allegations of Bribery of Corruption Act, 19 of 1994, and the Declaration of Assets and Liabilities Law, number 1 of 1975. These 3 acts repealed and introduced 1 act. That act is Anti-Corruption Act. What is the purpose? Give effect to the certain provisions of the United Nations Against Corruption and best practices. Independent commission. Establishment of an independent commission and direct the institution of Institute of Prosecutions and to promote and advance the prevention of corrupt practices and educate and raise awarenesses among the public. Now, under the 1994 Act, CIABOC has only investigations and prosecutions powers, investigating and prosecuting powers. But by this act, there are lot of powers and lot of responsibilities vested to the CIABOC by the parliament. So, this is the objectives in section 2. You have to read the Anti-Corruption Act because in 1 hour time it is impossible to explain you that is this type of bulk act, and this is the objectives, right? Objects of the act, right? Powers and functions of the commission, right? There are a lot of powers. Right. These are unique features. Then, මම එන්න අර මාත් එක්ක තරහ වෙන්නේ ඇයි කියලා මේ ළඟදී ඉඳා. දැන් ජෙනරල් ලෝ එක දන්නවා, ක්‍රිමිනල් ජෙනරල් ලෝ. දැන් අපි සමහර දේවල් මේ ඇක්ට් එකෙන් අපිට ආවන් පස්සේ අපි ඒ ඇක්ට් එකට වැඩ කරනකොට සමහරව හිතනවා අපි පවර් එක එක්සීඩ් කරනවා කියලා. Especially lawyers. එතකොට තමයි තරහ වෙන්නේ මේ අනිත් අය කරන්නේ නැති ඒවා කරනවා වගේ ඒවා. හරි? That's why I told this is the reason is the lack of knowledge. Right? What is the norm? Norm is that every citizen should know the law. But I have to say, every ministers, every parliamentarians, every judges and every lawyers first should know the law before the people. Right. These are the unique features. Section 4 and 17, independent procedure for appointment of commissioners and Director General. Director General specially appointed with special procedure, special independent procedure. I, as a High Court judge, forwarded my application to the Constitution Council and Constitutional Council interviewed me and gave the recommendations to the president, and president appointed. But I am not going to give more information about that because my appointment also that it has been challenged. That's why I'm not going to give any information about that. But read Sinhala one, not the English one. There are a lot of ambiguities between Sinhala and English versions of these acts. This Anti-Corruption Act, there are a lot of differences, lot of ambiguities. Very simply, I forwarded my application in Sinhala according to the Sinhala Act, which prevailed in Sri Lanka, the Sinhala version. And financial independence, section 31(3). This is 100% independent commission. How it is, what is the step that the parliament has taken to independently? We forwarded our annual budget estimation direct to the parliament, not to the finance minister. And parliament first has to pass our budget. That means any of the ministers or any of the government can't, because under the article 154 of the constitution, the monetary power with parliament. So anybody can't curtail the finance of the commission if the parliament passed. And we should have own staff, dedicated staff to our commission. There are some issues. I am not going to elaborate this here. I am not going to explain it that because I have no time to do that. Right. This is the section 73 to 78, protection of informers, whistleblowers, witnesses and other persons assisting the commission. Actually, you can see section 76, immunity to witnesses. There are immunity that who comes to the commission and lodge a complaint, any civil or criminal action can't be instituted against them. I will rush. This is the declaration of assets. This from section 79 or 92. I am not going to explain it. It's not directly relevant to you, that for the government officials. And another feature, the jurisdiction under the Money Laundering Act given to the Seaborg under this act. Early, we haven't, the Seaborg haven't money laundering jurisdiction. Right? Now, when any person commits an offense under this act, that means Anti-Corruption Act, which amounts to an unlawful activity within the meaning of the Prevention of Money Laundering Act number 5 of 2006, such person may be charged for an offense under the act in addition to an offense under this act. Right. These are the new offenses introduced by the Anti-Corruption Act. Then අපි පරණ bribery act එකේ තිබුණේ bribery ඒ කියන්නේ අල්ලස දූෂණය සහ ඊට අමතරව වත්කම් සම්බන්ධ වැරදි වගයක් තිබුණා under section 23A of the bribery act, the accumulation of assets. But in this act, the parliament introduced new offences. What? Trading in influence, bribery of a foreign public officials, bribery in the private sector, bribery in the private sector. This is a new concept, right? Failure to declare conflict of interest. It's an offense now. right? Offense related to sporting events. Now, I'm not going to, I have no time to explain because I want 1 hour for this one topic, one offense, because therefore I'm just giving an outline of this here. Right. Do you know this judgment? This is a very famous judgment. I used this judgment from my first day in, I think, Kantale also I used this. This judgment by the Justice Sarath N. Silva, when he was Court of Appeal judge, the Mansoor and another versus OIC Avisavel. It is under that yesterday I heard that lecture from Honorable High Court Judge Udesh Ranatunga. Haven't he said that this about this judgment? කියන්න ඕනේ සාමාන්‍යයෙන් කියන්න ඕනේ. Yes, this is under section 66 matter, but the concept is very nice. It is undoubtedly good law that where a statute creates a right and in plain language give a specific remedy or appoints a specific tribunal for its enforcement, the party seeking to enforce the right must resort to that tribunal and not to others. That means if there is a special law, you should follow the special law, not the general law. Right. By saying that, I will show that what are the unique features in Anti-Corruption Act. අපිට අපි සමහර දේවල් කරනකොට ඒවා power එක exceed කරනවා කියලා practicing criminal lawyers ලට හිතෙන්නේ නැහැ. But we are doing මම කවදාවත් නීතියෙන් පිට වැඩ කරලා නැහැ. ඒක මං ඉගෙන ගත්ත දෙයක්. මම ජස්ටිස් සෝසව හැමදාම මතක් කරනවා. මං ඉගෙන ගත්ත දෙයක් තමයි ලෝ එකෙන් පිට කවදාවත් වැඩ කරලා නැහැ. සමහර වෙලාවට කවුරු හරි ඇවිල්ලා අපිට කියන්න පුළුවන් මිනිස්සු 100ක් මැරෙනවා මේ ජජ්මන්ට් එක දුන්නොත් කියලා. හැබැයි අපිට against the law වැඩ කරන්න බෑ. මං හිතන්නේ අපිට හොඳම උදාහරණය තමයි ඉන්දියාව. ඉන්දියාවේ එහෙම කරනවා. Right? That if that law is not proper, you should change the law. But as a judge, you can't work against the law. ඒ සමහර අය practical දේවල් ගැන හිතලා වැඩ කරනවා. Against the law. මට ඕන තරම් ඒ උදාහරණ කියන්න පුළුවන්. ප්‍රසිද්ධ වෙලා තියෙන හින්දා එක සිද්ධියක් කියන්නම්. එක මොකද මේවෙන් තමයි ඉගෙන ගන්න ලේසි. එක බ්‍රිටිෂ් ලේඩි කෙනෙක් ලංකාවට ආවා. ඒ ලේඩිගේ ඔයගොල්ලන්ට මතක ඇති මේ සිද්ධිය. ඒ ලේඩිගේ මෙතන ගහලා තිබ්බා බුදුහාමුදුරුවන්ගේ පච්චයක්. හරි. එතකොට මේ ලේඩිව ලොකු එනකොටම ලොකු ප්‍රශ්නයක් වුණා ලංකාවේ බුද්ධ ආගමේ මිනිස්සුන්ට. එහෙම ලොකු ප්‍රශ්නයක් වුණා මේ පච්චයක් ගහලා මෙතන බුදුහාමුදුරුවෝ. මේ ලේඩිව පොලිසියෙන් අරන් ගියා නිගම්බ මැජිස්ට්‍රේට් ගාවට. නිගම්බ මැජිස්ට්‍රේට් ගාවට ගිහිල්ලා කිව්වා මෙයාව රටින් යවන්න ඩිපෝට් කරන්න ඕඩර් එකක් දෙන්න කියලා. මැජිස්ට්‍රේට් කෙනෙකුට වීසා ඇතිව මෙහෙට ආපු කෙනෙක් ඩිපෝට් කරන්න ලෝ එකක් නැහැ. He has no power to do. හරි. පොලිසිය කිව්වා මෙයාව දැන් ගහලා මරයි. මෙයාව දැන් ගහලා මරයි. හරි. Because of that, he gave that order. And that lady filed the fundamental right application. And Supreme Court decided that magistrate had no power to give that order. Right? If I were the magistrate, I didn't give that. Right? එහෙම මිනිස්සු මරන්න පුළුවන් ඈ? මේ බොරු කතාවනේ මේ ඇවිල්ලා කියන්නේ. හරි? බොරු කතා ඇවිල්ලා පොලිසිය කියනවා. හරිද? බොරු ඒ කියන්නේ that is the personality of the judge. You have to see what is the law. Then Easter Sunday attack එකෙන් පස්සේ මම කොටුවේ මැජිස්ට්‍රේට් වෙලා ඉන්නකොට මට ගෙනාවා සස්පෙක්ට් කෙනෙක් අර්ලියගහ මන්දිරේ ගාව ෆොටෝ ගගා හිටියයි කියලා. හරි? Now, under the Criminal Procedure Code, under section 115 of the Criminal Procedure Code, you can produce the suspect for an offense. Offense එක කියන්න ඕනේ. මම හිතුවා මොකක්ද offense එක? නෑ මෙයා ඒ කියන්නේ මේ ඉස්සරහට ත්‍රස්තවාදී ක්‍රියාවක් කරනවද කියලා සැකයි අපිට අපි ඒ ගැන විමර්ශනය කරනවා එතකන් රිමාන්ඩ් කරන්න කියලා. හරි? මොකද ත්‍රස්තවාදී ක්‍රියා කරනවා නම් under the PTA you can get the detention order. හරි? offense එකක් ඕනේ. නිකන් මිනිස්සු ගෙනල්ලා නිකන් දාන්න බෑනේ. right? I discharge. හැබැයි ප්‍රශ්නේ මොකක්ද දන්නවද? ඔය කෙනා ගිහිල්ලා බෝම්බයක් පුපුරවා ගත්තා නම් ඊට පස්සේ කියනවා මැජිස්ට්‍රේට් discharge කරන්න. හැබැයි ඉතින් කරන්න දෙයක් නැහැ. If there is no law, right? That's the thing. එතකොට මම මේ කිව්වේ දැන් we'll check the criminal knowledge of yours. Right. Search warrant එකක් ගන්න magistrate කෙනෙක් ගාවට යන්න ඕනේ. හරිද? Under what section of the Criminal Procedure Code? Section? මම ඒ sections ටික හිතාමතා දැම්මේ නෑ මෙතනට. Section 68 of the Criminal Procedure Code. But this is the power of the commission. Without going to the magistrate, the commission can issue the search order. Actually, I wanted to show you the sections. This is not the section, only section. This is a very small part of this section. There is a lengthy section here, section 45. කරන්න පුළුවන් දේවල් ගොඩක් තියෙන මම ඒවා පෙන්නන්න හිතාගෙන ආවා but I have no time to do that. You go and see that section 45, right? That every section I mentioned here, not in that only part I mentioned here. And so that's the search and seize. When you are going to seize, that you can, when you are going to search, you can seize the productions. And without court order, that is the thing, by the order of the commission. And section 47. මේක තමයි මාත් එක තරහ වෙන්න හේතුනේ මේ ළඟදී ඉඳන්. Right? Under section 47, any authorized officer of the commission may, without an order from the magistrate and without a warrant, arrest any person suspected of committing an offence under the provision of this act. That is a punishable offences. But I would like to say this. Until I appointed as a DG, any person has not been arrested by the bribery commission without warrant for corruption offences. ඒ කියන්නේ මේ පොඩි ගානක් පගාගත්ත මිනිස්සු ඕන තරම් arrest කරලා තියෙනවා. හැබැයි අර කියන corruption කියන offense එකට කෝටි ගණන් රජයට අලාභ වෙච්ච මේ මිනිස්සු වාසි ගත්ත ලක්ෂ කෝටි ගණන් ඒවා ගණන් කියව ගන්නත් බෑ සමහරට. ඒවට ඇරෙස් කරලා තිබුණේ. අවුරුදු 10ද 15ද investigations කරලා මොනවා හරි හොයාගන්න පුළුවන් වුණොත් හයි කෝට් එකේ නඩු දානවා. සමහර ෆයිල්ස් අවුරුදු 10 15 පාර. මිනිහෙක් ඇරෙස්ට් කරන්නේ ඇයි? නඩුව මැත්තේ යන්නේ. Why we are arresting person? In the criminal law, right? මම හොඳටම දැක්කා arrest කරන්නේ නැති වුණාම මොකද වෙලා තියෙන්නේ කියලා. Especially for the corruption. තේරෙන භාෂාවෙන් කියන්නේ ලේකම් ඇවිල්ලා කකුල් දෙක හොල්ල ඉඳලා යනවා මොනවා හරි කියලා බොරුවක්. ඇයි? එයා දන්නවනේ එයා arrest වෙන්නේ නැහැ කියලා. මේ ප්‍රැක්ටිස් එකක් නේ. ඒ ස්ටේට්මන්ට් එකෙන් ඇමති බේරලා යනවා. ඇමතිත් ඇවිල්ලා කකුල් දෙක හොල්ල ලේකම් බේරලා යනවා. But after that, who will responsible? I would ask this. Plant quarantine service certificate එක නැතුව පෝර ගෙන්නන්න බෑ කියන එක ඉතාම පැහැදිලි. එතකොට එහෙම ගෙන්නලා $6.9 million ලංකාවට අලාභයක් කරනවා. අපිද responsible. Right. I'm not going to give more information because I can't give them more information. This is in public domain. That was I give this information. Otherwise, there is a section 28, the secrecy provision. I can't give these informations evidence. And procedure for after arresting the person, right? There's another question. Criminal law කරපුවා නෑ ඒක මේ කෙනේ ගොඩක්. Criminal law කරපුවා හිටියා නම් හොඳයි. මොකද criminal law කරපු අයටත් මේක වරදින නිසා. ඌරන්ට වැරදුනාට ගොඩක් criminal law කරුනේ නැති අයට වැරදුනාට තේරෙන්නේ නැහැ. හැබැයි criminal law කරපු අය හැම දවසකම වරද්දන හින්දා. සහ magistrate-ලත් හැම දවසකම වරද්දන. Right. I will ask the one question. Under the criminal procedure code, කෙනෙක් without warrant arrest කරාට පස්සේ දැන් මම මෙහෙම කියන්නම්. Right. අනුරාධපුරේ නඩුවකට ගාල්ලේ අනුරාධපුරේ තමයි ඔෆෙන්ස් එක වෙලා තියෙන්නේ. ක්‍රයිම් එක කමිට් කරලා වෙලා තියෙන අනුරාධපුරේ. ගාල්ලෙන් arrest කරනවා කෙනෙක් without warrant. Without warrant is a cognizable offense. Suspect produce කරන්නේ කොහෙටද? කොහෙටද produce කරන්නේ? ගාල්ලට කියන අය අත උස්සන බලන්න. සමහරව ඉන්නව කොහෙටවත් ප්‍රොඩියුස් කරන්නේ නැහැ සස්පෙක්ට්ව ගෙදර යවනවා. ඇරෙස්ට් කරාම කොහෙටද ප්‍රොඩියුස් කරන්න බෑ පැය 24ක් ඇතුළත නේද? ඈ? ඔව් දැන් මං අහන්නේ ගාල්ලෙන් ඇරෙස්ට් කරේ. With warrant there is another procedure under section 50 of the criminal procedure code, right? Without warrant arrest කරාම ගාල්ලෙන් crime එක commit උනේ අනුරාධපුරේ. කොහෙටද ප්‍රොඩියුස් කරන්නේ? ගාල්ලට කියන අය. හරි. වෙන කොහෙටවත් කියන අය ඉන්නේ. ඔව් හරි. ගාල්ල තමයි ආසන්නම. නෑ මං අහන්නේ ඔයා නම් පොලිස් ඔෆිසර් ඔයා කොහෙටද ප්‍රොඩියුස් කරන්නේ? It's practically. Yeah? Yes. Yes. Anuradhapura. Why? So you should produce the person within 24 hours. How do you produce within 24 hours? Waiting in high speed dala now it was. This is the issue of Sri Lankan law. Right? මේ හැම එකක්ම ක්‍රිමිනල් ප්‍රොසීජර් කෝඩ් එකේ තියෙනවා. You read ක්‍රිමිනල් ප්‍රොසීජර් කෝඩ් එක නැහැ මෙතනනේ. මට ගන්න වෙන්න පුළුවන් නම් වෙන තැනකින් මට පෙන්වන්න පුළුවන්. section එක. Can you take that in the internet? Section 36 and 37. ඕක කියවලා උත්තරේ කියන්න බලන්න. Maheshwar, not the Maheshwar Tidri. Section 36. Said 36 of the Criminal Procedure Code. 36. No, section, read the section 36. Have you taken? Right. This is a section. A peace officer making an arrest without warrant shall, without unnecessary delay and subject to be provisions herein contained as to be bail, take or send the person arrested before a magistrate having jurisdiction in the case. Having jurisdiction in the case. ගාල්ලේ මැජිස්ට්‍රේට් ජුරිස්ඩික්ෂන් තියනවද? නැහැ. එහෙනම් ගාල්ලේ කිව්වේ?
Practical difficulty.
What's a practical difficulty? You have no right ගාල්ලේ මැජිස්ට්‍රේට් නම් ඔයා මොකද කරන්නේ? ඔයා ගාල්ලේ මැජිස්ට්‍රේට් නම් මොකද කරන්නේ?
දැනුවත් වෙනවා.
නෑ ඔයා ගාල්ලේ මැජිස්ට්‍රේට් නම් නෑ හැමෝම කරන්නේ මේක. හැමෝම ලංකාවේ හැමෝම කරනවා.
Remand කළා as soon as possible අරයට මේ
යවනවා remand. You have no jurisdiction to remand the person.
Otherwise he will escape from the
No. It's very clear no. Jurisdiction මේක සිංහල එකේ තියෙන අධිකරණ බලය ඇති අධිකරණය වෙත රැගෙන යා යුතුයි. ඒක අනුරාධපුරේට. Right. ඔයාගේ ප්‍රශ්නේ. පැය 24 යනවනේ අනුරාධපුරේට ගෙනියනකොට. ඔය ඒකනේ කියන්නේ. Section 37. Section 37.
24 hours එකපාර තව ඩියුටිස් තියෙනවා කරන්න තව
නෑ හරි පයින් එක යන්නේ පයින්
no highway
Section 37 කියවන්නකෝ Section 37 තියෙනවා any peace officer shall not detain in custody or otherwise confine a person arrested without a warrant for a longer period than under all the circumstances of the case is reasonable and the period shall not exceed 24 hours exclusive of the time necessary for the journey from the place of the arrest to the magistrate. ඔයා සතියක් පහින් ගෙනිච්චත් ඒ සතිය ආයෙත් වෙන්නේ නැහැ පැය 24ට. හැබැයි මුළු ලංකාවෙම මැජිස්ට්‍රේට්ලා හරිද? කරන්නේ ගාල්ලෙන් රිමාන්ඩ් කරලා අනුරාධපුරේ යවන එක. Right?
ඒ report එකක් දාන්න.
මම එහෙම කළා නෑ. මම දන්න තව එක ජජ් කෙනෙක් එහෙම කළා නෑ. හරි? හරි. දැන් ගෙනාවම මොකද කරන්නේ? ගාල්ලේ මැජිස්ට්‍රේට් මම ගෙනාවම මොකද කරන්නේ? මොකද ලියන්නේ?
ෆෝම් කරන්න. කළා කියනවා
jurisdiction නෑ as soon as
jurisdiction නෑ
මං කියන්නේ ගෙනාවු එක්කෙනාගේ නම ලියනවා පොලිස් සැරයන් අහවලා හරිද අධිකරණ බලය ඇති අධිකරණය වෙත ඉදිරිපත් කිරීම සඳහා අපරාධ නඩු විධාන සංග්‍රහයේ 36 වෙනි වගන්තිය යටතේ නැවත සැකකරු බාර දෙමි. කෙනෙක්ලා යන්න මට කුණුහරුප කීකේ තමයි ගෙනියන්නේ. ඒක වෙනම කතාවක්. හැබැයි that is the law. Right. That is a different of this act. See, because of that practical difficulty, they have seen that. Here said before the nearest magistrate. I want to show this different. They are said nearest magistrate, not the නැත්තම් කොළඹ විතරයි jurisdiction තියෙන private වලට. ඔක්කොම මිනිස්සු කොළඹ ගේන්නේ. Right? So මේක තව තියෙනවා මේ section එකේ. හරිද? මම මේ highlight කරලා තියෙන්නේ that is a different. මම මේ general law එකත් එක්ක මේ law එක වෙනස් වෙන තැන් කියන්න හදන්නේ. හරිද? And section 49 provided the commission may video record the examination of any person under the provisions of the make it ගොඩක් තියෙනවා. Make it ගොඩාක් මේ section එක කියවන මම මේ section පෙන්නන්න හිතන් ආවේ but I have no time to do that. මේ section එකේ තව ගොඩාක් තියෙනවා. හරි? මේ section එක පිටු 4ක් විතර දිගයි මේ 49 කියන එක. හරි? එතකොට මේකේ තියෙන දැන් පොලිසියකට ගියාම ස්ටේට්මන්ට් එකක් දෙන්න පොලිසිය ලියනවනේ. අපිට තියෙන පවර් එකක් මේ section එකෙන් ලියනවට අමතරව වීඩියෝ රෙකෝඩින් එකක් කරන්න. හරි? ඒ කියන්නේ එයාගේ ස්ටේට්මන්ට් එක රෙකෝඩ් කරන්න පුළුවන්. හරි? ඊට පස්සේ ඉතින් ආයෙ ගිහිල්ලා උසාවියේ එක එක ඒවා කියන්න බෑ. හරි? වීඩියෝ කරන්න පුළුවන්. right. එතකොට 49(1) FGH ඒ ටික මම පෙන්නන්න හිතාගෙන හිටියේ දැන් ඒ ටික පෙන්නන්න මට වෙලාවක් නැහැ. හරි? ඒකේ තියෙන්නේ හරි lot of hours. ඒ කියන්නේ ඕන government institution එකකට මොන හරි information එකක් දෙන්න කිව්වහම දෙන්න ඕනේ. Any government institution. Then auditor general also. Right? කාටවත් claim කරන්න බෑ තමන්ගේ secrecy provisions. See, provided that any mail, this is the last part of this section H, provided that any person to whom the commission issue any direction under this subsection shall comply with such direction, notwithstanding anything to the contrary in any other law. Right. You read these sections, please. And section 51. There's another thing. Taking of fingerprint impression, photographs, non-inmate samples, blood samples, and voice samples. Right. Under the general law, what is the section? What's the section? Then කෙනෙක්ගේ fingerprints ගන්න ඕනේ කියමු. ලේ රුධිරය ගන්න ඕනේ කියමුකෝ. වෙන procedure code එකක් කියලා දෙන්න. anti corruption act එක කියලා දෙන්න ආවේ. 124 is a general section, but it's for taking the other samples. 1 to 123 is amended subsequently. Right. නිකන් general question එකක් අහන්නද? මේක වෙන්නේ. මොකක් හරි? හිතන්න පුරුදු වෙන section එක. උසාවිය කාට හරි ලේ දෙන්න කියලා order එකක් දෙනවා. ඔයාගේ blood samples දෙන්න කියලා order එකක් දෙනවා. හරිද? දුන්නට පස්සේ මිනිහා කියනවා මන් දෙන්නේ නැහැ කියලා. කොහොමද ගන්නෙ? කොහොමද ගන්නෙ? දැන් සමහර අයගේ හිතේම වෙන ඒවා තමයි උඹට දෙයක් කනලා ඉවර වෙලා
There's a presume.
ඈ
There's a presume if it's refused to give.
ගන්න ඕනේ 114 of the evidence ordinance as a presumption, right? ගන්න මහන්සි වෙන්න එපා.
Only the declaration we get, he refused.
Yes.
That's only.
එතකොට මේකට දැන් යන්න ඕනෙත් නැහැ. උසාවියට ගිහින් ඉල්ලන්න ඕනේ නැහැ. Commission can take, right? And this is actually with his consent. His consent, they can take, otherwise commission can give the order. If refused, that presumption will apply. Right. And also we can send the productions to the governmental list without going to the court, right? අර උසාවිය හැමදාම තියන්නේ අර කසිප්පු හැම මූලික සාක්ෂි ගොනු කරනවා ඊට පස්සේ අරස පරීක්ෂකයට යවනවා සංදේශය ගොනු කරන්න එහෙම කියනවනේ. right. රජයේ රස පරීක්ෂකයට සාමාන්‍ය වන්නේ මොන section එකේද? I want to say this. මේ ඔක්කොම මේ criminal procedure code එකේ තියෙනවා. හැමදාම කරනවා. හැබැයි දන්නේ නැහැ ඒ කරන්නේ කියලා. මේ නිකන් කරන්නේ නැහැ මේවා. ඕන්නම් දැන් කියවල බලන්න ගිහිල්ලා. government analyst productions යවන්න ඕඩර් කරන්නේ මොන section එකෙන්ද? Hmm? (116) subsection 3 of the Criminal Procedure Code. Right. That is for your extra knowledge. Again, restraining orders. Right? You know, under the Money Laundering Act, that the officer not belong to the rank SSP can give the freezing orders. And that freezing orders can be extended by the court, High Court. But here, the commission can do that. This is also the big section. This is the lengthy section. Gives the restricting orders. You can't the property, that if the property is going to transfer to other person, the commission can give the restriction order to the land registry. You can't do that. That RMB to RMB, the commission can give that type of order. And also, I am not mentioning here under section 53 because I wanted to show this. This is a very lengthy section. I wanted to show you these sections, but yeah, I have no time to do. Under this section, that commission can impound the passport of the suspect, even, but only for 3 months. Only for 3 months because it's ex parte. Right? Right. උසාවි වලින් විදේශ ගමන් තහනම් කරනව නේද? ඕන තරම්. හරි? කොහෙද තියෙන්නේ? කොහෙද තියෙන්නේ? ඔය හැම එකක්ම කොහේ හරි තියෙනවා. ඒක තමයි මේ වෙලා තියෙන දේ. කොහෙද තියෙන්නේ? දැන් මේ මං කියන ඒවා කවුරුත් හිතලා නැහැනේ. මේවා හැමදාම කරනවා. හරි? හැමදාම කරනවා. නික පොඩ්ඩක් වෙනස්ව හිතන්න කියලා තමයි කියන්න දෙන්නේ. එතකොට you can be a brilliant lawyer. හැමදාම කරන දේවල් වලට වඩා. මගෙන් එක දවසක් ලෝයර් කෙනෙක් ඇහුවා අපි කවදාවත් හිතෙන්නේ නැති එකක් මේ මම අහන්නේ. දැන් අරකට උත්තරේ මම කියන්නම්. ඒකට උත්තරේ ආගමන විගමන පාලනයේ 53 අයන්න වගේ. 53 of the Immigration and Immigration Act. ඒක යට තමයි මැජිස්ට්‍රේට් කෙනෙක් ඔය passport impound කරන. That's a word they use, impound. No, විදේශගත වළක්වීම අර එහෙම නෙවෙයි. පරිරෝධනය කිරීම. right. මගෙන් ළඟදී ලෝය කෙනෙක් ඇහුවා මම දන්නේ ඔයගොල්ලන්ට ඒකට උත්තරයක් තියෙනවද කියලා. මිනිහෙක් උසාවිය ආවේ නැති වුණාම ඇයි වරෙන්තු කරන්නේ කියලා. ඇයි වරෙන්තු කරන්නේ? මිනිහෙක් අද ඔන්න උසාවිය ආවේ නැහැ. දැන් අපේ MC එක දැකලා තියෙනවනේ. නම කියවනවා මිනිහා නැහැ චූදිත වරෙන්තු අපනොතීසි. නේ? චූදිත වරෙන්තු අපනොතීසිනේ. කපත් ඇයි වරෙන්තු කරන්නේ? ඇයි ආයි සිතාසියක් කරන්න පුළුවන්?
contempt of court.
ඒ කොහෙද?
අයි පෙනී සිටීමට නියෝගයක් තියෙනවා.
ඔව් කඩ කරාම වරෙන්තු කරන්නේ. ඇයි වරෙන්තු කරන්නේ? These are practical things. But legally I ask. ඇයි සිතාසි කරන්නේ නැත්තේ? කවුරු හරි යවුවොත් නෑ. දැන් ඇයි සිතාස් දැන් මට පුළුවන් අද මිනිස්සයා ඇවිල්ලා නැහැ. මං සිතාසියක් නිකුත් කරනවා. එක දවසයිනේ ආවේ නැත්තේ.
අද පැමිණිය යුතු බව දැනුම තියෙනවා.
දැනුම තියෙනවා. ආවේ නැහැ.
නමුත් දැනුම් දීම අවශ්‍ය නැහැ. ඉතින්
හරි. ඇයි වරෙන්තු කරන්නේ? අල්ලන් එන්නනේ වරෙන්තු කියන්නේ අල්ලන් එන්න කියලා පොලිසිය.
සම්ෂන් එකක් තියෙනවා මෙහා උසාවි
නෑ ඔය අර එහෙම යන්න එපා. ඔබ සෙක්ෂන් එක තියෙනවා. ක්‍රිමිනල් ප්‍රොසීඩියර් කෝඩ් එකේ තියෙනවා. section 63. read the section 63. ඒකේ තියෙනවා වරෙන්තුවක් නිකුත් කළ හැකි අවස්ථා. ඒකේ පළවෙනි එකේ තියෙනවා 63 එක යන්නේ can read it. හරි? යම් කෙනෙක් සිතාසියක් නිකුත් කිරීමට පෙර හෝ සිතාසියක් නිකුත් කිරීමෙන් පසු ඒ තැනැත්තා අධිකරණයට නොපැමිණෙන බවට විශ්වාස කිරීමට කරුණු තිබේ නම් එයාට සිතාසියක් නැතුව වරෙන්තුවක් නිකුත් කරන්න පුළුවන්. හරි? එතකොට අරකේ වෙන්නේ මම විශ්වාස කරන්නේ ආයේ කියලා දාවේ නෑනේ. හරි. ඊළඟට ඒකේ දෙවෙනි සෙක්ෂන් එකේ තියෙනවා සිතාසිය බාර දීමෙන් පසු ආවේ නැත්තම් ඒකටත් වරෙන්තුව. ඒකයි සිතාසිය බාර දීලා තියෙද්දි ආවේ නැත්තම් වරෙන්තු කරන්නේ. That is in section 63. මම මේ කියන්න උත්සාහ කරන්නේ මේ ඔක්කොම තියෙනවා හදලා අපරාධ 1979 හදලා තියෙන්නේ. හරි 79 ශ්‍රීමපති කෝඩ් එක. Right. Special investigation techniques. There are a lot of techniques we can use for our investigations. Interceptions of communications. Unlocking of data and information. We have a lot of powers. Right? But in this section, with the permission of the court, High Court, අපිට ඕන නම් ටෙලිෆෝන් ටැප් කරන්න පුළුවන්. Right? Right. Section 65. Now that I explain about the investigations, this is the prosecution. Right? There is a unique feature here. Right. Again the criminal procedure code. මහේස්ත්‍රාත් අධිකරණයේ චෝදනාව දාන්නේ කවුද?
අසංකරයි මැජිස්ට්‍රේට් frame the charges.
මැජිස්ට්‍රේට් කෝට් එකේ චෝදනාව දාන්නේ පොලිසිය කියන අය අත උස්සන්නකො.
frame කියන එක
මැජිස්ට්‍රේට් කෝට් එකේ චෝදනාව දාන්නේ පොලිසිය කියන අය.
frame charges by the magistrate.
නෑ මම අත උස්සන්නකො පොලිසිය කියන අය. මොකද අපි දකින්නේ පොලිසිය තමයි දාන්නේ. ඇත්තනේ?
පොලිසිය තමයි
ඔව්. ආයි ප්‍රායෝගික කියනවා.
මහේස්ත්‍රාත් සංකරණය.
the magistrate.
ඇයි මැජිස්ට්‍රේට් අසං කරන්නේ? OIC ට මසං කළා දාන්න.
OIC is the
එයා
investigator.
පාටි එකක් නේ prosecution.
කාගෙන්වත් සෙක්ෂන් එක කියවෙන්නේ නෑ. 182. හරි? If there is a reasonable grounds, the magistrate should frame the charge. හරිනේ? magistrate තමයි හදන්න ඕනේ. ලංකාවේ magistrateලා අම්බාන එක වැඩ. 12ට ගෙදර යනවා හැබැයි සමහර අය. හරි? ඒ හින්දා ඒකත් හදා ගන්න පොලිසියට කියලා. හරි? නෑ ඒක ප්‍රැක්ටිකලි සමහරලාට කරන්න බෑ මොකද ඔක්කොම ෆැක්ට්ස් නැති නිසා. හරි? හැබැයි ඕනේ නම් මන් තීරණය කළා තියෙනවා ඒ වෙලාවේ හැම එකම එන එක හදන්නේ නෑ. grounds තියෙනවද කියලා බලන්න පුළුවන්. මොකද grounds තියෙනවද කියලා බලන්න ඕනේ magistrate. එතකොට පොලිසිය මොකද කරන්නේ? දැන් පොලිසිය මොකද දාන්නේ? plaint එක. under section 136. දැම්මහම grounds තියෙනම් 182 න් හදනවා. This is a different here. I want to show this. Notwithstanding anything to the contrary any other written law, the Director General in the accordance with the subsection 1 of this section shall have to power to institute proceedings in the magistrate court through a charge sheet, right? Signed by the Director General. And the section 136 of the Code of Criminal Procedure Act number 15 of 1979 shall not apply for the purposes of this section. Again, Director General දාන්නේ පැමිණිලා නෙවෙයි direct charge sheet. ඇත්තටම මේක that is the one of a progressive step have taken. මොකද උතන පොඩි ප්‍රශ්නයක් තියෙනවා. Our system is an adversarial system, right? How the magistrate hear that same case, which he framed the charges. Magistrate criminal procedure court එකේ කියනවා මම චෝදනාව හදලා ඔයාට මමම නඩුව අහනවා. Is it an adversarial system? මේක වෙන lecture එකක්. The mixture of the investorial system and adversarial system in our criminal procedure code is the different topic. There are some investory powers to the magistrate. අපේ system එකේ එහෙම එකක් තියෙනවා. හැබැයි මේක එක correct කරනවා. Right? Prosecution එක තමයි දාන්නේ. charge sheet එක. Right? දැන් මේවා දන්නේ නැති වුණාම තමයි ඊළඟට එනවා magistrate අස්සම් කරලා නැහැ charge sheet වගේ objection. මේක කියවන්නේ නේද? හරි? This is a call witnesses අර ඔයගොල්ලෝ දන්නවනේ then අපේ criminal procedure code එකේ section 167 right anytime before the judgment the court can amend the indictment or the charge හැබැයි ඒකේ කොහෙවත් නැහැ witness ගැන නඩු බාණ්ඩ ගැන මුකුත් නැහැනේ හරි හැබැයි interpret කරගෙන තියෙනවා නඩු බාණ්ඩයි witnesses ලයි charge sheet එකේ කෑලි කියලා. ඒ නිසා ඒවත් කරන්න පුළුවන් කියලා. හැබැයි criminal procedure code එක කියවනකොට හරියට එහෙම එකක් නැහැ. හැබැයි මේකේ දෙනවා හරියටම section එකක්. Call any witness or use of produce any document which is not specified in the list of witnesses or list of documents. මේකේ prosecution එකට පුළුවන් ඉල්ලන්න ඕන වෙලාවක තමන් list කරපු නැති එකක් ඇතුල් කරන්න. කියන්නේ amend කරන්න. Right? Withdrawal of indictment. High court එකට විතරයි මේක දීලා තියෙන්නේ. I don't know why that is. Special provision එකක් දීලා තියෙනවා for withdrawal of the indictment, the bribery conviction. Under the general law, indictment එක withdraw කරන්න තියෙන section එක මොකක්ද? Before the High Court. There are two sections, not the withdrawal, one section. 194.1 is nolli prosecute. AG informed to the court, I am not going to prosecute the case further. That is called nolli prosecute. And the section says, so after the judge should discharge the person, discharge, not acquit. And 194.3 says, with the permission of the High Court judge, Attorney General can withdraw the indictment. If the High Court judge give his consent, that High Court judge should discharge the person under 194. But this is a special section. මේ section එක විශේෂයෙන් කියන්න ඕනේ. Now you can, when you appear before the High Court for a bribery or corruption charge, right? You can make this application, right? Practicing lawyers la itiyana hondai kiyala man kiyanne ekkinda. Under section 67, I will read the Sinhala one. Section 67. මේ පනත යටතේ වරදක් හෝ ඊට වැඩි මේ ඒ ටික තමයි මේ මුලින් තියෙන්නේ. නඩු තීන්දුවක් ලබා දීමට පෙර කවර වූ අවස්ථාවක අධ්‍යක්ෂ ජනරාල්වරයා විසින් කොමිෂන් සභාවේ අනුමැතිය සහිතව දෙවන උපවගන්තියේ නිශ්චිතව දක්වා ඇති කරුණු නිසි සැලකිල්ලට ගනිමින් හා තුන්වන උපවගන්තියේ සඳහන් කරන ලද කොන්දේසි එකක් හෝ ඊට වැඩි ගණනකට යටත්ව මහාධිකරණයේ අවසරය මත ඒ චෝදිතයාට එරෙහි වන අධිචෝදනාවන් ඉල්ලා අස් කර ගනු ලැබිය හැකියි. දෙක අධ්‍යක්ෂ ජනරාල්වරයා විසින් පළවෙනි උපවගන්තියට අධිචෝදනාව ඉල්ලා අස් කර ගන්න අවස්ථාවකදී ඔහු විසින් මෙන්න මේ කරුණු සලකන්න ඕනේ. ජාතික යහපත සහ පොදු යහපත. වරදෙහි වින්දිතයන්ගේ අදහස් සහ චූදිත තැනැත්තා හෝ ඔහු වෙනුවෙන් ඔහුගේ නීතිඥවරයා විසින් කළ හැකි ඉදිරිපත් කිරීම. පිළිබඳ නිසි සැලකිල්ලක් යොමු කළ යුතුය. තුන අධ්‍යක්ෂණවල විසින් පළවන උපකන්ති යටතේ අධිශෝධනාව ඉල්ලා අස් කර ගන්නා විට නියමිත කාල සීමාවක් තුල ඉටු කළ යුතු පහත දැක්වෙන කොන්දේසි වලින් එකක් හෝ කීපයක් චූදිතයා මත පැනවිය හැකිය. කොමිෂන් සභාව විසින් නිකුත් කළ ලද පාඨයක් භාවිතා කරමින් මහාධිකරණ ඉදිරියේ ප්‍රසිද්ධියේ කනගාටුව ප්‍රකාශ කර ගැනීම. ප්‍රකාශ කර සමාව ගැනීම. කොමිෂන් සභාව විසින් නිශ්චිතව නිශ්චය සඳහන් කරනු ලබන පරිදි වරදේ වින්දිතයන්ට වන්දියක් ගෙවීම. right? මේ පනත යටතේ වරදක් සිදු කිරීමෙන් ඔහු වැළකෙන බවට ප්‍රසිද්ධියේ බාර ගැනීම. හෝ තෝරාපත් කරන ලද හෝ පත් කරන ලද යන දෙආකාරයේ රජයේ නිලයන් දැරීමෙන් ස්ථිරවම වැළකෙන බව. Under these conditions, the Director General can withdraw the indictment. Right? Not under the section 194(1) or 194(3). Right? Samahar avasthavala very practical. This is a very practical section. Right? සත්‍ය වශයෙන්ම කෙනෙක් තමා කළපු වරද ගැන පසුතැවීමට ලක් වෙනවා නම් සත්‍ය වශයෙන් හරි සහ වෙනත් කාරණා දැන් සමහර වෙලාවට පුළුවන් අපේ තියෙන සමහර නඩු තියෙනවා ඇකියුස්ඩ් අවුරුදු 70ක් විතර වෙනවා. එතකොට සමහර රාට වෙච්ච ගවර්න්මන්ට් එකට වෙච්ච ලොස් එක කෝටියක් විතර වෙනවා. ෂුවර් එකටම නඩුව අහලා ඉවර වෙනකොට ජීවත් වෙන්නේ. හරිද? සමහර වෙලාවට මේක යටතේ දෙන්න පුළුවන්. ඔයා කෝටිය ගෙවන්න. The Director General will withdraw the case. Right? පුළුවන් තියාගන්න. එහෙම ක්ලයන්ට් කෙනෙක් ආවොත් මේකෙන් කරන්න පුළුවන්. තව ගොඩක් ඒවා තියෙනවා. දැන් ඔයගොල්ලෝ දන්නේ නැති ඒවා තියෙනවනේ. දන්නේ නැහැ කියලා මම හිතනවා. ප්ලීස් දැන් plea bargaining කියලා procedure එකක් තියෙනවා දන්නවද? Criminal Procedure Code very recently amended for plea bargaining. Plea bargaining agreements. මම ඒකනේ කියන්නේ ලංකාවේ laws හදලා වැඩක් නැහැ. Right. The final part. This is also the unique point, that is the same section for the accomplished witnesses under section 259, but there is a special section. Okay, right. I'm sorry. I want to stress these important points. Right? 1. Section 145 of the Anti-Corruption Act. Every person required by the Commission to give any information on any subject which it is the duty of the Commission to inquire into under this Act, and which is in power to give shall be legally bound to give that information. A person shall comply with the provisions of subsection 1, notwithstanding any obligation as to secrecy or otherwise restriction on the disclosure of information enforced by any written law, agreement, contract or otherwise. Right? I am not going to go further. Mr. Amarasuriya knows that what one issue has already raised about this section. We'll see what happens. Right? I just mentioned the law. And section 30. This is also the one issue raised. Right? 30 subsection 2. Right? A member of the Commission or the Director General or any officer or employee of the Commission or any person whose services are retained under section 27 shall not be required to produce any document received by or to disclose to any court any matter or thing committed in the notices of the Commission in the course of any investigation conducted by the Commission under this Act, except as may be necessary for the purpose of the proceedings before the court of law for the contempt or for an offence under this Act or for an offence under Chapter 11 of the Penal Code. මේ කියන්නේ මොකද දන්නවද? මේ කියන්නේ ඇන්ටි කරප්ෂන් ඇක්ට් එක යටතේ තියෙන නඩුවකදී හෝ කන්ටෙම්ප්ට් charge එකදී හෝ ඔය chapter 40 chapter 11 එකේ කියන්නේ forged documents හදපු එකදී වගේ එකදී හැර කිසිම වෙලාවක කමිෂන් එකේ තියෙන ඉන්වෙස්ටිගේෂන් එකක් ගැන ඒ ડોකියුමන්ට් එක හෝ ඒකට රිවීල් වෙච්ච ইনফර්මේෂන් එකක් දෙන්න කියලා කිසිම උසාවියකට ඕඩර් එකක් දෙන්න බෑ. Right? So any court, right? The other thing, these all are because I have filed that one because I am not going to, that is before the court, in the Court of Appeal. I filed a written application under this section against one magistrate. One magistrate one magistrate noticed the our officer, and I filed a written application. Right? Therefore, I am not going to explain further. Right? And this one, Section 168 of ACA. The jurisdiction vested in the Court of Appeal by the Article 140. What is Article 140? Writ jurisdiction. Right. Of the Constitution shall in the respect of application in which relief is sought against the Commission be exercised by the Supreme Court and not by the Court of Appeal. Supreme Court. Against the Commission, if you want to file the writ application, you should go to the Supreme Court, not the Court of Appeal. Right. मान्य प्रश्न है मित्र वेला. You can ask any question. No.
It's a group.
ඒ වගේම තමයි හොඳටම ලෝ දන්න කෙනෙක් අතට ගියාම වෙන දේ තමයි දැන් වෙලා තියෙන්නේ. ඔය කියන දේ no, they can't do, no? They're according to the law. Law වලින් එහා discussion නැහැ නේ මේව. Discussion තියෙනකොට තමයි දැලිපෙහි අවුල.
The Commission wants to do one person.
Yeah. ප්‍රශ්න තියෙන අහන්න. What? මොකද්ද? Oh. නෑ. This is the law of the country. Right? එහෙම වෙන්නේ නැහැ. ඒ කියන්නේ මේක දැන් ඉස්සෙල්ලා පටන් ගත්තේ ඔක්කොම ඇන්ටි කරප්ෂන් වලට සපෝට් නේ.
Yeah.
නේ?
Yes.
Right. දැන් මම අන්තිමට මේක ඉවර කරන්නම් මේකෙන්. හරි? දැන් සමහරු හිතන් ඉන්නවා මට I want to tell this. සමහරු හිතන් ඉන්නවා අපි ප්‍රැක්ටිස් කරන ලෝයස්ලා ඉන්නේ දෙපැත්තක කියලා. No. We all are same side. කවුරු හරි ඉන්නවද දූෂිතය වෙනුවෙන් පෙනී ඉන්න කෙනෙක් ඉන්නවා කියමුකෝ. එයා දූෂිතයෙක් වෙනුවෙන් පෙනී ඉන්න නීතිඥවරයෙක් දූෂිතයෙක්ද? No. That he is doing his duty. Right? He is legally bound by the Supreme Court rules. Right? එහෙම වෙන්නේ නැහැ. එහෙම වෙන්න ඕනේද නැහැ. This is their practice. This is their duty. I know that. අවසාන වශයෙන් මම එක කතාවක් කියන්නම්. මේ කතාව අහලා. හරිද? You know that Justice Sarath Ambedkar murdered, right? Justice Sarath Ambedkar මැරුවට පස්සේ Pottenaufer වැළුවා, right? Pottenaufer, that the person who planned this and conspired to murder the Justice Ambedkar. He is the main suspect. එයා ඇල්ලුවට පස්සේ දැන් මමත් එතකොට ජුඩිෂියරි එකට ආපුම කාලේ 2004 ආරච්චියක් ආවා ප්‍රෙසිඩන්ට්ස් කවුන්සිලර් තිරන්ත වරලියද්ද පොට්ටනවුෆර්ට අපිය වෙනවා කියලා. Right? All the judges were anxious actually because that he's a lawyer like can do miracles. Right? හොඳටම කලබල වෙනවා තිරන්ත වරලියද්ද අපිය වෙනවා දැන් පොට්ටනවුෆර්ට. පොට්ටනවුෆර්ව ගලව ගන්නත් පුළුවන් නේද තිරන්ත වරලියද්දට කියලා. And they rushed to the CJ. I also were there to meet Justice Sarath Silva. Right? ඊළ කිව්වා සර් මාර වැඩේ සර් තිරන්ත වරලියද්ද අපිය වෙනවා. Justice Ambedkar මරපු පොට්ටනවුෆර්ට මෙච්චර ඩ්‍රග් ඩීලර් කෙනෙක් තමන්ගේ ජජ්මන්ට් එක දවස් දෙකකින් දෙන්න තියෙන හින්දා බැරුවේ. හරි? කේස් ෆයිල් එකක් තිබ්බ කාර්යයේ එඩි දෙන වෙලාව. හරි? මේ වගේ මිනිහෙකුට තිරන්ත වරලියක් දැපිය වෙනවා. Justice Sarath Silva told. මොකක්ද ප්‍රශ්නේ? නෑ මේක මෙහෙම වෙන්න පුළුවන්ද ලෝකෙම අඩුකාරයෙක් මරලා හරිම අසාධාරණ විදියට වෙන හේතුවකුත් නැතුව තමන්ගේ ජජ්මන්ට් එක දෙන්න තියෙන හින්දා සරත් සිල්වා කිව්වා නෑ අනිවාර්යයෙන්ම පොට්ටනවුෆර් වෙනුවෙන් ලෝය කෙනෙක් ඉන්නවා අනිවාර්යයෙන්ම මොකද he has to be represented by the council එතකොට තමයි මේ process එක හරියට වෙනවා කියලා පේන්නේ. එහෙම නැත්තම් නඩුකාරයෙක් මැරුවාම තව නඩුකාරයෝ ටිකක් නඩු අහලා ලෝය කෙනෙකුත් නැතුව මිනිහෙක් එල්ලනවා. හරි? That is the thing. You have to understand this, right? Yes, it has to be represented. That is the process of law. That is the justice. So I want to say, Mr. Amarasuri, some lawyers think that here, that because of a lack of knowledge, we acted according to our law, and some are going to make some doubts that they have doubts that what we are exceeding our powers. We are doing our duty for justice, and lawyers also doing their duty for justice. Both of us assist court to do justice. That's it. Yes.
So, my question. දැන් සර් කේස් එකකින් පස්සේ discharge වුණු accused කෙනෙක්. ඒකට යාට පුළුවන් සිවිල් ඇක්ෂන් එකකට යන්න damages ගන්න. අපි
Acquit වුණොත් discharge වෙනවා.
acquit වුණොත් ඒකට මේ false allegation එකක්. ඒ වගේ වෙලාවක සර් order කරන්න බැරිද documents ගන්න කියලා? ඒ කියන්නේ
order කරන්න කියන්නේ?
දැන් සර් කිව්වනේ අරවා
නෑ අපෙන් ඉල්ලන්න පුළුවන් අපි දෙනවා.
ඒ කියන්නේ judge කෙනෙක්
මේ කියන්නේ එහෙම එකක් නෙවෙයි. මේ කියන්නේ අදාළ නැති නඩුවට අදාළ නැති ඉන්වෙස්ටිගේෂන් එකක් ගැන වෙන ඉන්ෆර්මේෂන් එකක් හරි ડોකියුමන්ට් එකක් හරි දෙන්න කියලා ඕඩර් කරන්න බෑ කියන්නේ. ඒ නඩුවට අදාළ එකක් ගැන නෙවෙයි.
රටෙන් පිට අල්ලස් දීමයි අල්ලස් ගැනීමයි සිදු වෙනවා ලංකාව තුල සිදු වෙනවා. හරි ලංකාවේ මුහුදු තීරේ. ඔව්. ඔව්. මම තේරුණා. ඒ කියන්නේ අල්ලස දෙන්නේ හේදිද? අල්ලස දෙන්නේ හේදි පාර ගන්නෙත් හේදි. ඔව්.
ගැනීමට අදාළයි.
ඔව්. Kapila Chandrasena ගෙනලු.
Before marking the conclusion of today's symposium, I cordially invite Mr. Rajiv Amarasuriya, the President of the Bar Association of Sri Lanka, to make the concluding remarks for the day.
Thank you very much, Susanthi. We have now come to the end of Legal Symposium 2 in this very exotic location of Budavalva. I think all of you will agree with me when I say that it has been a very thought-provoking, interesting 2 days of some very, very good lectures. I think it is difficult to compare between the different sessions. We all are very good. Yesterday we started off with Dushanta Silva and Milinda Vattegedra speaking on the importance of wildlife, nature, animal rights, and of course the legal provisions. I think gave us an opportunity to think a little differently from our traditional way of thinking and realizing what a wonderful resource we have, and that we as lawyers need to do something to support that process. Then we had Honorable Udesh Rantunga speaking to us on Section 66 applications. We all know he's an author, he has written the book, and again many questions were asked, and it was interesting. Of course, time was limited, but I think there was a lot of learning. We had Mr. Upali Mohti, President's Counsel, speaking on fair trial, again a very interesting program. Then we had Mr. Shiranti Gunawardana on notarial practice. Many questions were asked, I recall. Then last evening we had the fireside chat where all of you posed questions to me. And I think that was also very interactive, engaging, and I also take back a lot from that discussion in leading the BASL going forward. Today we had Mr. Priyant Talagayavanna speaking on debt recovery. I saw a lot of you surrounding him at the end, asking questions. Obviously, it was very, very engaging. And now we just finished the last session with the Director General of the Bribery Commission, former High Court Judge, Mr. Ranga Disanayake, explaining to you the nuances and the differences under the new regime of the Anti-Corruption Act. We must agree to disagree. There may be some things we don't agree with, but that is how it is on a professional level. I'm thankful to all the resource persons for coming here. It's not easy to come to Developer. You had come 3-4 hours. There is no reward as such. You will have a photograph of yourself in a frame, which we give. But that is what is special about this legal profession. All of us, all of you, are part of this noble profession. And they have come to share their knowledge, expertise, and in the hope of making a difference. All of you are here to learn and share knowledge, share ideas, and of course, an opportunity to network, relax. I saw many of you on the jeeps going to see the elephants yesterday. It's nice to see. And this is what we want in the Bar Association. This is Symposium number 2. Symposium number 3 was being discussed last night at the networking event. One of the participants here has promised to arrange another exotic scenic location. I hope that comes through, and when that does, we will inform you. As you know, the symposiums get closed up very soon, so you must register very as soon as possible. Before I conclude, I must thank the BASL Webinars and Seminars Committee, the co-chairs, the secretary, Chatur Galhena, and the treasurer, Pasindu Silva. And then we have the two conveners who are dedicated to the symposiums, Mr. Pandula Vanyarachi and Ms. Lusandi Pereira, who also did the comparing these 2 days. So I'm very appreciative and thankful to all of them. And also Ms. Nikini Mapitigama, who's not in the committee this year, but she was in the committee when I was last chaired it, when I was secretary, and her support also is invaluable. Then we have the BASL staff, and we all coordinated with them. CEO, Mrs. Surani Samarasekara, Mr. Prakalathan, and we have Amidu from the IT office here, looking after the live stream. This is the type of knowledge sharing I want to make available to every member of our profession. If everyone can listen to this, it will add value. And that is why we decided this year that we will live stream all of this to the membership. I can't force the members to watch, but what I can do is make that opportunity available. Those who want to learn, those who want to develop, and those who want to make a difference now have the opportunity of learning. Either you can watch it as it goes live or later on the BASL YouTube channel. So I encourage all of you to encourage all of your colleagues to make use of these wonderful opportunities. For them, it's absolutely free of charge, and upgrade and update. I think we must also thank the hotel and also the gentleman who's doing the photography. All of you have, I think, made a difference, added value. And as president of the Bar Association, the only request I have, two requests. One is participate in all our programs. Many are free of charge. And the second request I made in the morning yesterday, do come forward and help us. This is an association owned by all of you, not any particular person or group. It is our association. Whatever contribution you are willing to make, the time you want to spare, please reach out to us and let us together make a difference for our legal community and also the wider interest of our country. So thank you very much to all of you. I think we are moving for lunch, and then hopefully we'll see you at the next event of the Bar Association. Thank you very much.
Thank you, sir. This marks the successful conclusion of the Legal Symposium number 2 of 2025-2026. On behalf of the BASL Webinars and Legal Symposiums Committee, I extend our sincere thanks to all of you for your active participation and engagement in this symposium, which has been instrumental in making this event a success. It has been an immense pleasure meeting and interacting with you, and we look forward to welcome you at our upcoming BASL events. Thank you. Have a nice day.